deliberate on any issue, whatever he has delivered. They can put questions if you have any suggestions, then also you can put forward.
My question, one question. Who will guard the judges? Who will guard the judges?
Sir, it's
Hello. It's the judiciary only. Because judiciary is the supreme factor in our country where it has to rectify itself as well it has to see that it is not forced by social forces.
So my question to you is that
I am not satisfied with the answer, sir.
Sorry, you can give inputs.
Actually, judges can be removed from the office on the ground of proved misbehavior or incapacity, and by the parliament by passing the resolution, and on the basis of Judicial Inquiry Act 1968. So they are accountable to the parliament. What I think.
Of course, but as per the preamble of the constitution says, the supreme power lies in the hands of the people of our country. If there is great uprisings because of the media, then definitely it will go against the judges, and even the parliamentarians will be forced to pass a resolution to remove the judge because of the vote bank policy. Please remember that. Any other questions, please?
okay. So thank you very much, Dr. Ram Shankar Das. I would like to know things. Supposing you are talking about the media drive.
The media drive.
Yes, but there has been a political ownership of the media houses.
Sure.
And do you think that this paralyzes the democratic framework in India rather than promoting transparency, rather than attaining judicial accountability?
So, with due respect, I would like to say that public opinion influences law, and law also indirectly influences public opinion through media. Media is one of the factors. Okay. Now, this is well known by the politicians, so they are running media houses. They are using to push their own political agenda. Okay. So, it is not possible for us to stop the politicians to control media. That's one part. But judiciary can take proactive steps to see that the misinformation, wrong information, or which is not true, is not pushed to the public. If it is done, there will be uprisings like the Renzi uprising in various countries, Nepal and all that. So it's the duty of the court also to see that the media is not misused.
Thank you very much for your deliberation. I would like to call upon the next presenter, Samuel Ajak Pradhan.
Thank you, sir.
Okay. Be present.
You can continue with the next one, sir.
So, the third presenter is Priti Koikia Polai, and I will Orpita Prabhusin.
Mike Center.
Are they present?
Yes.
Yes. Okay.
So within 5 minutes, try to wind up. Okay. So remote maybe. Remote.
Never mistake law for justice. Justice is an ideal and law is a tool. A very good morning to each and every respected persons. I am Priti Palai, BLLB 5 year, 4th semester of Kota Law College. So today I will be presenting a paper ensuring justice is seen to be done in the digital era. First of all, digital transformation of judicial process refers to the integration of modern information and communication technologies into the functioning of courts. Judicial accountability, being answerable for the decision, conduct, and performance is a significantly strengthening through the use of technology. Technology plays a crucial role in strengthening judicial accountability, which means that judges and court are answerable for their actions, decisions, and efficiency. Through digital systems, e-courts and online case filing, virtual hearings and video conferencing. Third one, digital case management systems. Fourth, AI-based legal research tool, online judgments and case leads. Electronic evidence management. Then role of technology in digital transformation of judicial process. Transformation of judicial process refers to the use of modern technology to improve how court function, deliver justice, and ensure judicial accountability. It involves replacing traditional paper-based and manual court procedures with digital tools such as e-filing, virtual hearing, online case management systems, and digital record keeping. Reason of using digital. Transformation uses technology to make the justice system faster, more transparent, more efficient, and more accountable, ensuring that courts serve the public fairly and responsibly. Then role of technology in judicial efficiency. First of all, reduce case backlog, saves time and cost, faster case tracking and scheduling, minimizes paperwork, improve coordination between courts. Then challenges and concerns. Digital divide limiting access and disadvantages, group data privacy and cyber security. Risk over reliance on technology affecting human judgment, need for training of judges and court staff. Thank you. Over to Arya.
Now I would like to discuss the statutory provision that legally support open justice and the use of technology in judicial process. Section 327 of the CRPC, which is now Section 352 of the BNSS, expressly states that the place where a criminal court is held shall be deemed an open court to which the public generally has access. Live streaming is the definition of this section. Section 153B CPC. Civil court must be open to the public. Court may hold proceeding in camera if necessary in the interest of justice. Section 275 CRPC, which is now Section 295 of the BNSS, was amended to allow the recording of the evidence through audio, video, electronic means in the presence of the advocate of the accused. Section 4 RTI Act 2005 obligated on public authorities to maintain record in a forum that is appropriate for computerization and to protectively disclose information. Section 80 of BNSS encourage use of technology in criminal investigation and proceedings, promote transparency and efficiency. Then key technology used in judicial process, e-courts and online case management system, electronic filing of case, virtual hearing and video conferencing, digital record and document management, AI-based case tracking and analytics, online publication of judgment, and court order. Then suggestion, legal framework for digital courts, clearing laws and guidelines should govern virtual hearings, digital evidence and online dispute resolution to ensure fairness and accountability, public awareness and legal literacy. Citizens should be educated about e-court and digital judicial service so they can actively participate and hold institutions accountable. Solution. Through technology integrated digital case management system, courts should adopt on-file platform that connect police, prosecution, courts, and prisons to ensure seamless information flow and accountability at every stage. Cybersecurity measures, strong data protection laws, and secure digital infrastructure are essential to safeguard sensitive judicial data and maintain public trust. Then to conclusion, digital transformation has the potential to revolutionize judicial process by making them more transparent, efficient, and accountable when implemented. Responsible technology strengthens judicial integrity, reduce delays, and enhance public confidence in the justice system. However, success depends on proper infrastructure, legal safeguard training, and inclusive access to digital justice. Thank you.
Thank you, Critical Development as well as Mr. Rajaswini. You have nicely elaborated on the digitalization of the judicial process and the new technology that has been used, especially the virtual proceedings. And nowadays we are getting in YouTube also various court proceedings. So to a great extent, I feel that transparency is being maintained. People can come to know that what is going on in the courtroom. Then Odisha High Court has also taken initiative to go for the YouTube live streaming. So, thank you very much for your presentation. At least I feel that students from the BLLB onwards, they are actually at least participating in national seminar. That is the, I feel that is a good sign for our legal education system of the state of Odisha. I feel other students also to come forward, to present, so that you can refine yourself in the due course of time by getting some sort of feedback, suggestions, and all. My suggestion will be to reduce the actually paragraph by paragraph. Don't write paragraph by paragraph whenever you are presenting. Make it a slight. It means it should be point wise, not paragraph wise. That is what I want to say. Other things you have covered very nicely. At your stage, at least, I will appreciate whatever you have presented. Thank you very much.
Thank you so much.
Thank you. I'd like to call upon the next paper presenter, Suprabha Mandal. Present?
Yes.
Okay.
Remote.
Good morning, respected teacher, chairperson, honorable guests, discussion faculty members, and your participants. I am Suprabha Mandal, LLM first year, student of Ganjam Law College. Today I will be presenting my seminar to Technology and Judicial Accountability. Judicial accountability refers to the responsibility of court function in transparent, fair, and efficient manner while maintaining public trust. In recent years, technology has emerged as a powerful tool to improve how the justice system works. It helps courts become faster, more transparent, and more accessible to people. Digital transformation. Traditionally, courts rely on paperwork, manual filing, and physical records, which often cause delay and identity. With digital transformation, many judicial processes are now conducted through e-filing, online cases, databases, and digital records. This shift not only save time but also ensure better record keeping, reducing the chance for error or influence. Data analytical. Artificial intelligence and data analytics are increasingly supporting judicial work. AI tools help judges and lawyers conduct legal research quickly by analyze legal volume of case law. Data analytical also conduct to voluntary performance and identify study in case disposal. This technology assists decision making but do not replacement human judgment with replacement central justice. Digital cases management and transparency. Technology has significantly improved case tracking and management. Courts now use software to monitor cases, progress, schedule, hearing, and store documents securely. At the same time, public access to justice is improved through online portal, citizen and chat cases, structured down, order, and cases judgment. In some courts, live streaming of proceeding has featured strengthened transparency and public confidence. Future heading. Next. Future court video conferencing have made justice more accessible, especially for people who cannot travel long distance. They save time, reduce costs, and allow courts to function even during emergencies. This shows how technology can make the justice system more inclusive and efficient. Challenge and safeguard. Despite many benefits, technology to bring challenges such as data privacy, concern digital divide, and the risk of over-reliance and automated system. Therefore, strong legal safeguard, proper training for judge and lawyers, and human oversight are essential to ensure technical use of technology. And final, technology is transformation the judicial by improving efficiency, transparency, and access to justice. However, it must be used carefully so that it supports judicial independence and fairness rather than replacing human resource. With the right balance between influence and safeguard, technology can strengthen judicial accountability and fully greater public trust in the justice system. Thank you.
Thank you, Prabha, for your nice presentation. Indeed, the role of technology, especially the AI, use of AI, is increasingly being seen in our judicial process, especially the young advocates. They are using the artificial intelligence. Thereby, it has actually created some sort of disturbance also. Recently, the matter before the Honorable Chief Justice of India, he has also questioned regarding the use of AI, especially generating some sort of fake citations and presenting it before the Honorable Court. That has actually disturbed the judicial proceedings. So I feel that whenever you are presenting this particular paper or you are writing the full paper, you should focus on that particular issue as well. And there should be some sort of guidelines as well. There should be some sort of questions or some sort of guidelines regarding the use of AI by both the members of the judiciary as well as by the advocates appearing for the parties. So, which will actually at least enhance our actually judicial functioning, I think, in a great way. AI is a good tool, but that should be used for the beneficial purpose for the good of the people only. The use of technology has negative ramifications as well. So I think you should focus on those aspects. That will be better for you. So thank you very much for your nice presentation.
Thank you, sir.
I'd like to call upon the next paper presenter, B. Deepika Naidu and Amit Kumar Sahu. They present?
Yes, sir.
Yes. Okay.
A very fresh morning to all of you. Myself, Deepika Naidu, and I am a BA LLB student of Khordha Law College. Today, I am here to talk about judicial accountability, strengthening public trust in judicial system. And my title is From Courtroom to Headlines: Media as a Tool of Judicial Transparency. So let's begin with the first point. Justice must not only be done, but must also be seen to be done. Introduction. In contemporary democracies, justice no longer operates in isolation. Court proceedings are instantly transmitted, analyzed, and debated in public chambers. The media functions as an intermediary between the judiciary and society. transforming courtrooms into matters of public discourse. Then we will discuss about what is trial by media. Trial by media refers to the phenomenon where media platforms assumes an adjudicatory role by performing or projecting conclusions about guilt or innocence before judicial pronouncement. Then we will discuss why this topic matters. In this digital era, high profile cases generate immediate public reactions. News, debates, and social media narratives often shape public perceptions before judicial determination. Such prejudgment risks influencing investigations, witnesses, and even institutional confidence in judiciary. Then we will discuss about some constitutional framework. Article 19(1)(a) guarantees freedom of speech, expressions, and forming the basic press freedom. And Article 21(2) permits reasonable restrictions including contempt of court and defamations. And Article 21 protects the right of life and personal liberty, also including in right to privacy, encompasses the right to a fair trial. Then I would like to invite my co-author, Mr. Amit Kumar Sahu, please.
Some case law for this presentation. Judicial, judicially view on media responsibility. First case law is R.K. Anand versus Delhi High Court. This is the important case law for us. Supreme Court held that the media cannot conduct parallel trials. Similarly, in Sahara India Real Estate Corporation Ltd versus SEBI, the court allowed postponed orders to prevent pre-judicial reporting. Some real life examples: the Jessica Lal murder case. Strong media coverage helped bring public attention to the case, leading to renewal investigation and eventual conviction. This shows the positive role of media in promoting justice. But, however, in the ROC Talwar murder case, excuse media speculations and sensational reporting, creating prejudice and damage reputations, highlighting the danger of the trial by media. Then here are some solutions. Clear, clear demarcation between reporting and opinion making, strengthen or safe regulator and frameworks, judicially safeguard in case of prejudicial publicity, public awareness of the presumption of innocence, responsible digital media governance. It is the very important part of media trial. Some issues created, but some positive things we are allowed. Some issues are made by medias. But media is important for us. Media is important for our country. Then media some restrictions. Why there are restrictions? Media are not allowed to president house. Why? Because president house is the important part of our country. They are secret meetings, some secret knowledge. They are not provided by public. They are provided from public leaders. Then our country is very developed. Then power media is a power support. But media have some restrictions is more important for us. Then thank you for us. I will very happy to stand there. Thank you. Thank you, Guru.
Thank you for your nice presentation. Topic is from courtroom to headlines. Media is a tool of judicial transparency. Indeed, the role of media, especially in the era of social media, has actually increased tremendously, and it will greatly enhance the judicial transparency and judicial accountability. And do you think that media trial has certain sort of negative ramifications as well? Because other proper presenters have also deliberated on this issue. But I would like to know from you what are the negative ramifications of this media trial or media, how it negatively impacts our judicial independence.
Sir, in
Yeah.
under Article 19(1)(a) guarantees everyone the right to speech, and media also has the right to free from press. And if the media violates anyone's opinions like private liberty, then media has some restrictions under Article 19 some reasonable restrictions are there. एंड if any मतलब मीडिया अगर कुछ ऐसा करती है कि मतलब उनकी रिपोर्टिंग की वजह से कुछ पब्लिक की प्राइवेसी को हैम्पर होती है, तो आर्टिकल 21 ये डिक्लेयर करती है कि सबकी प्राइवेसी है। तो मीडिया अपनी जगह ठीक है, कोर्ट अपनी जगह ठीक है। तो मीडिया और कोर्ट दोनों के बीच ऐसे मतलब कुछ भी प्रॉब्लम होती है ना, तो आर्टिकल 21 वहां पे ऑर्डर होती है। तो इसलिए मीडिया को सम रेस्ट्रिक्शंस होना चाहिए, जैसे कि मैं कुछ सोल्यूशन दूंगी। जैसे कि जर्नलिस्ट जो हैं उनको कोर्ट की लीगल जो भी है लीगल नॉलेज के बारे में सबको पता होनी चाहिए। एंड दूसरी बात है कि उनकी जो भी जजमेंट्स होती हैं ये सारे लोग क्या करते हैं ना, पहले से वो मीडिया कवर कर लेती है, जो कि पब्लिक ओपिनियन को इन्फ्लुएंस करती है। तो जजेस आर ऑल्सो इन्फ्लुएंस बाय द मीडिया। तो ऐसा मतलब क्या है?
Okay. So, I would like to actually highlight only one point. That is, I have seen on experience, especially after we are getting in some sort of YouTube videos, especially of the judges, and that is actually cropped. And some persons are sensitive case वाला न्यूज वाला वो पर्सन वाला थोड़ा सा हाईलाइट करके मीडिया छोड़ते हैं, या जो सोशल मीडिया इन्फ्लुएंसर है वो वाला छोड़ते हैं, जो सब्सटेंस है उस पे नहीं जाते हैं। तो maybe the judge has made some sort of oral remark. It is not a part of the judgment. He has made an oral remark, but it is actually highlighted more, and thereby actually creating some sort of impression, negative impression certain time. That is what I feel one of the negative ramification of the digitalization of this process. And because it is related to social media, that is why I asked. So thank you very much for your nice presentation.
Thank you, sir. Thank you.
Sir, next we have 4 online participants. Now starting with Pranav Kumar, Miss Larisa, K.M. Aishwarya, and Mini Gupta.
Okay.
So we can start with Pranav Kumar.
Yes. Sure.
क्वेश्चन पचारा थिला सर रीजनल रेस्ट्रिक्शन से पहले मैडम रीजनल रेस्ट्रिक्शन का को आर्टिकल रो से कोटा 21 रे नो 21
Okay. Mr. Pranav Kumar, are you online? Mr. Pranav Kumar, are you online? Okay. I hope he left, but let's wait for a few seconds.
Yes, no problem.
Yes, yes. Pranav Kumar, are you ready to present, or shall we put you later? Okay, we can start with the next participant, Miss Larisa. Are you there? Miss Larija, are you online? Okay, the next participant, KM Aishwarya. Are you there, madam?
Next one is there. Many.
I think next participant, Minnie Gupta madam is there. Are you there, madam? Yeah, you can start present.
सर बाकी लोग को जॉइन हुआ कि जॉइन ମୁଁ ଏଫସି କା ଗୋଟେ କଥା ଟିକେ କହିଲା ତମ ପଛରେ ଆମେ କୋଉ ବିଜନେସ୍ କରେ ସେଟା କୋଉ ଅଛି ସେଟା ସେଟା କି ତମ ସେଟା ସେ ଅନଲାଇନ୍ वाला ସମସ୍ତଙ୍କୁ କଲ୍ କରିବ ଖାଲି ରବନ 2 ମିନିଟ୍ ପରେ ଆସିଲି କହୁଛି ରବନ 2 ମିନିଟ୍ ପରେ ଆସିବ ये ऐश्वर्या एडे मु मारथली जे लोक डिमांड में लगे ऐसे रामन ने इसके रामन ने तांगर पुरी ना रामन ने एडा नाइस से ता पिपड़ी प्रेजेंट करो सर मोर क्लिक कर जे हला नहीं पर देखो ना एडा रिमांड में लेटर कर एडा पिपड़ी शो करे सारा शो करे सर
You can present orally also if you are facing any sort of technical. Yes, yes, it is visible now. You can start.
मुस्लिम नहीं Chapi. Kau lagi. Chapi. मेरे मुंह से ठीक पड़
Madam, time is running short. Could you please conclude fast?
कॉमेडी बोले ऐसे सार बोले नहीं सर क्या बोले ऐसे
Thank you very much, Vinny Gupta ji, for your nice presentation. I'd like to know from you, since your topic is the role of judicial activism in advancing environmental justice. So, I would like to know about the limitations, I mean, the scope of your study. What years or which years are you are covering and how you have designed your paper. Regarding that, I would like to know because you have already highlighted. I have seen the cases from 2013, 17, and the previous one also. You have shown the chronology also. But on which year to which year, from which year to which year you are focusing?
Yeah. My God.
Okay. Another query I have. You have mentioned about NGT, National Green Tribunal, but I have seen some of the judgments, or you can say some of the orders passed by the NGT. Recently, there was a case of state of Assam, especially the Bagjan issue, where there was actually explosion because of the in the oil fields. Actually, there was explosion. And the surprisingly, NGT actually appointed a person who belongs to that particular company itself, who has exploded that particular Bagjan area, and he was appointed actually one of the member to look into those affairs. So, do you think that is this extensive tribunalization in environmental matters, where actually we need speedy justice, because after NGT will go to obviously to the High Court and thereafter to Supreme Court. Do you think that speedy justice in environmental issues are being actually hampered due to the tribunalization? Okay, thank you very much. We can go ahead with the next presentation, next
Uh,
online presentation. Thank you
Mr.
very much.
Pranav Kumar is available online. Pranav, okay, please continue.
Ganjam দিয়ে দিয়েছি আছে না ওকে yes whatever
Yes, audible.
Kumarji, you can conclude. You can conclude. Yes.
Okay, thank you so much for the presentation. Thank you, because we are running short of time. Next, I would like to request, I think KM Aishwarya madam is there. So, Aishwarya madam, are you there? No. Larissa madam, are you there? Please present.
Yes, yes, you proceed. Yes, visible, visible. You can go ahead.
minutes. I will join you. Second euro. Basically, इसको पढ़ो. Hi. Serious. Right? Jonan. कहीं घंटे बड़े दिन उनको
Thank you, Madam Narija, for your nice presentation. You have focused on two, three things. I think judicial activism, judicial restraint, and public trust. My query will be like this: that do you think that the constitutional prerogative of the judiciary and attaining the public trust, art is not contradictory. Art is not contradictory. I mean, whenever you are going to judiciary, will try to attain the public trust by go by the popular notions what the people want. Will it not fail to discharge the constitutional mandate given to the judiciary to go by the evidence, go by the law, go by the judicial pronouncements, precedents, thereafter giving a judgment, or the judiciary will go by the popular notion and try to attain the public trust thereby. Yes, yes, okay. Next question will be just a smaller one. How the judiciary will ensure the public participation? Because in one of the slides you have mentioned about the public participation in the judicial decision making. How is it be possible? Thank you for your nice deliberation. We can take up any offline presenter or online, whatever is
Online or over?
online over. Huh? Okay. So I'd like to call upon Samuel Isaac Pradhan. Is he present or anybody else? Yes, yes. You come and present your presentation.
Good morning, respected dignitaries.
ତାକୁ ଦେଇଦିଅ ରିମୋଟଟାକୁ ଧରିକି ଗାଁଠୁ ଦବ କି?
Once again, very good morning to respected dignitaries. And all the participants. Sorry for this. My title of the paper is Judicial Accountability, Strengthening Public Trust in the Judicial System, exploring best practices from different countries of the world for judicial accountability. Myself, Samuel Isaac Pradhan. I am proud to be a Semitician and student of GLC.
This one previous, this one next.
Judicial accountability is the foundation principle of judiciary. This paper explores the critical nexus between accountability and public trust. Yes, the public trust is important here. The judiciary is only currency. Public trust is the only currency judiciary. My paper is exploring best practices from different countries of the world with fairness comparison with our judiciary system. My paper structure is this. When we are thinking about UK judiciary system, there is a JCIO, Judiciary Conduct Investigation Office, which publishes nearly 2,000 cases by investigating. When we are comparing with this March 2025, one controversy is involving Justice Yashwant Verma. I don't want to explain more that case scandal. Restorative justice versus institutional silence. Really sorry. Global best practices, we can say that Canada, in 2017, Federal Court Justice Robin Kent, what he made a derivative statement. I don't want to read that. So determined his conduct was profoundly destructive to public confidence and recommended his removal. Immediately he resigned. Let us come to the reality, to me. In July 2025, civil judge Aditi Gajendra Sharma, I'm sorry, taking name. So many cases are there. Institution is silent. Efficiency and meritocracy, global screening, global best practices. New Zealand Commissioner's Model efficiency filters up to 90% of regular complaints, keeping the disciplinary track clean. Meanwhile, South Africa also adopted hybrid model. We can say lot of participants also say that backlog of cases. We can one thing again say within 1 month, Supreme Court, contradictory to its own judgment, Arameli judgment, global practices, progressive legal system are increasingly shifting away from cash there. I have the money. I can get the debt. Yes, nobody accept it. But it is reality. I can get the debt immediately. I have that 5 crores to deposit in court. I can get bail. But what about the poor people? I can get parole and I can enjoy festivals. Yesterday only, we knew that Supreme Court of USA bulldozed Mr. Trump. I can say, Pagla. Supreme Court of USA, courage to bulldoze the USA president who destroyed the harmony of world. the Supreme Court of USA destroyed the thought of Mr. Trump. But when we are discussing about that, myself, I am finding myself that electoral bond. It takes what I am to say. Supreme Court of USA took only 10 months to give its decision. Electoral bond, nearly 7 years, and no punishment. Thank you. Digital divide, paperless, we know all that things. Now, when we are, yes, we are in AI field. Yes, there is a always fear of content of vote. But his media is doing their work. Everything is okay. If between you and me there is a conflict, yes, today I will say you, I will see you in court. This is the thing what a common man says in India. But first I said that trust is necessary. Yes, we have that trust in judiciary. That's why a common people today saying, I will see you in court. Maybe the global system takes more than marks, but I can say proudly, our judiciary system have 100 of marks. That's why I am saying, I will see you in court. My finding, accountability, inefficiency, inequity, delays. My suggestions, universalize intermediate sanctions, modify ethics, statutory oversight, democratize oversight, and institutional silence. The study concludes that judicial independence must never mutate into a will for impunity, while major democracies like the UK and South Africa utilize dynamic intermediate sanctions. Yes, sanctions are necessary. To enforce probity, India's reduced impeachment only architecture has allowed institutional silence to fester. Let us make a breeze. Let us say a state within a state, service to justice.
Thank you, Samuelji, for a nice deliberation. Since your topic is learning from the best practices or exploring the best practices from different countries, I'd like to know, do you think that the best practices of the different countries uh, can it be adopted in Indian judicial system? Because the judicial system of a particular country differs in their legacy, differs in their structure. So, would it be easier on our part to incorporate the best practices of the other countries into our legal system?
With the vast population, with the vast challenges, it is very difficult, but I think we have to adapt, sir. Otherwise, no choice.
Okay, thank you. Thank you very much. So, I think the fourth topic is it is.
Yes, sir. The
Subject is
fourth
finished.
theme is over, sir. Now we'll start with the fifth theme.
Okay.
So you can just kindly address regarding the reducing pendency of backlog cases, challenges and solutions. You can talk few things about it.
Okay.
Then we'll start with the first participant who will be offline.
Okay. So, just to give a general remark regarding the papers that were presented in the regarding this fourth sub-theme regarding the exploring best practices from different countries of the world for judicial accountability. Indeed, 9 to 10 paper presenters were there. I think 9 presented. I guess.
2 are absent.
Okay, 2 are absent, means 8 have presented. What I have seen is it's a mixture of the paper presentation is mixture.
Because
I mean,
yesterday some
the
people have
students from
communicated.
the LLB, they are also presenting. they are making an endeavor, which is praiseworthy, I would say. And one thing I would like to say that we need to use technology to police our research work, but excessive use of the technology to prepare a paper is somehow becoming dangerous nowadays. That is what I feel, and I think that more use of skill, your own skill. Try to develop your own skill rather than depending upon excessive use of technology. Technology is good, okay. In various research papers, also various Scopus journals, Q1, Q2, these journals are also having some sort of policy regarding use of AI in policing the language of that particular paper and all. But my point will be to see that the less use will be the better. I think that is what I will like to say. That is my observation. And regarding the fifth thing, we can start. Perhaps that is what my observation is. Actually, I want to request them to use less, less AI, less use of the digital tools. You can use some sort of reference management software, just like Jotero or another other tools for preparing your research paper. These are quite handy. These are quite useful for reference management and all. These are, I think we all will agree on this particular point. Thank you very much for the nice deliberation. I thank the all the paper presenters of the fourth theme, and I look forward for the fifth thing. That is the reducing pendency of backlog cases, challenges, and solutions. Uh, so we can start.
Yes.
Yes, the first paper presenter is Orosis Rao and Satyaprakash Behra.
Good afternoon to all. Respected session chairperson, respected teachers, and my dear friends. Myself, Orosis Rao, and I am here with my co-author Satyaprakash Behra. We are from Khoda Law College. Today, we are going to present our paper on case management system and time-bound justice delivery. Justice delay is justice denied. This principle is not merely a slogan, it is a constitutional mandate. Under Article 21 of the Indian Constitution, the right to speedy trial is a part of right to life and personal liberty. The Supreme Court in Husainara Khatun versus State of Bihar clearly held that speedy justice is a fundamental right. However, despite this constitutional guarantee, Indian courts face serious problems such as huge case backlogs, frequent adjournments, manual record management, unequal distribution of workload. This creates delay, uncertainty, and loss of public trust. To address this issue, case management systems have been introduced. So, what is case management system? A CMS is structured judicial mechanism that ensures cases move through predefined stages within fixed timelines, and it includes e-filing of cases, automated scheduled hearings, monitoring deadlines, digital tracking of case progress, performance dashboards. The objective of CMS is simple: time-bound justice delivery. Statutory provisions also support this goal. Section 346 of BNSS mandates expeditious trial and discourages unnecessary adjournments. Amendments in CPC, especially in Order 10 and Order 15A, promote case management hearings. The Commercial Courts Act 2015 strictly enforces timelines for filing written statements and evidence. Our research problem was to examine whether the CMS actually reduced delay and improve efficiency.
we formulated the hypothesis that CMS significantly improves time-bound justice delivery. Now, I would like to invite my co-author to explain the rest.
Thank you, Rajesh. Hello everyone. Good afternoon. I would like to speak about methodology, findings, and suggestions. In our research, we adopted a mixed methodology approach. We analyzed constitutional provisions, statutory frameworks, landmark case laws, data from the National Judicial Data Grid. Our findings clearly show that courts using digital case management show better disposal rates, automated scheduling reduces idle time between hearings, real-time tracking, increased accountability, differentiated case management, where cases are categorized based on complexity, ensures harsher resolution of simpler disputes. The Supreme Court has repeatedly emphasized time-bound justice. In Salim Advocate Bar Association versus Union of India 2005, the court upheld amendments introducing case management reforms under SPC. Similarly, P. Ramachandra Rao versus State of Karnataka 2002, the court reiterated the importance of speedy trial while balancing procedural fairness. However, we also identified challenges like lack of digital infrastructure and technical training, resistance to procedural change, and infrastructure limitations. Based on our study, we suggest mandatory implementation of CMS in all courts, continuous judicial training programs for all judges and all court staffs, strengthening digital infrastructure, performance-based monitoring system, public access to e-courts, and startup strength. Now, I would like to conclude that case management systems are not merely administrative tools. They are constitutional instruments uphold Article 21. Time-bound justice strengthens public confidence, protects fundamental rights, and promotes the rule of law. Therefore, effective implementation of CMS is essential for transforming the Indian justice delivery system. Thank you.
Thank you, Mrs. Rao and Dr. Prakash, for your innovative topic. I would like to say because this is a new area. I would say case management system, and the counterpart we are using is especially at institutional level. We have some sort of legal management system also. There in our university and for the state of Odisha, actually for the state government departments, we are having LMS. Actually, this is a legal management system through which the cases are tracked and how many supposing cases are new cases are filed, which cases are the party has been given a notice, what is the petition, what are the wise comment, whatever has been given counter affidavit, all these are uploaded and given a particular state. But it is uploaded in the website. So these are quite handy tools, I would like to say, that the technology has given, and accordingly, we can achieve access to justice and time-bound justice. Thank you very much for your nice deliberation. I would like to call upon the next paper presenter, Dr. Nilanchala Sethi, sir.
Thank you, sir. Esteemed chairperson, rapporteur, responsible faculty members, dear student friends, and give my heartfelt thank you to give me an opportunity to present my paper. My paper,
judicial accountability in India and overview. As a citizen of this country, all of we know that our country is the world's biggest democratic country. And executive, legislative, and judiciary are the three pillars of this democratic setup. So every functional institution of the state play a vital role for welfare of the people and development of this nation. But at the same time, according to Article 50 of the Indian Constitution, every institution is independent its own sphere. But during that time, our judiciary take a vital role, not only the protector of the Indian Constitution, that is supreme law of the land, at the same time it provides protection of the fundamental right of the citizen. And as a citizen of this country, in India there is a federal form of government and division of the power is there and two set of government is there. During that time there must be highly essential and independent impartial judiciary. So Indian judiciary play a vital role as a custodian of the Indian Constitution and also protector of the every person's right as well as the institution's right. But all of you know, everyone is liable for his own act. It may be a person or may be an institution. So our judiciary also liable for his own act because everyone is depend and believe on the Indian judiciary when and where in such circumstance who is facing such problem during that time for the justice he go to court because it is the primary function of the state to provide justice to its people. In this Viksit Bharat, the role and responsibility of the judiciary day to day enhancing. But at the same time, in some instances, there are such corrupted charges against judges but according to Article 124, Clause 4 and 5, the removal of the judges are there. But at present, no Supreme Court judges of this India, according to this procedure, is removed from its seat. But at the same time, no doubt there are such rules, regulation and principles are there. He may be a person or nation, everyone is guided by the law. Nobody is above the law, but there must be highly essential to take such responsibility. No doubt law regulates the human being and also institution. But at the same time, there must be highly essential. He may be a person and also he may be a Chief Justice of India who occupied a vital seat. He must be perform his duty and guided by the morality because law regulates the human being. But at the same time, as a citizen of this country, there is a duty and responsibility to do such act which is highly essential for this democratic setup, a democratic country, and also people. Thank you, all of you.
Thank you, Nilanchana sir. In a nutshell, you have deliberated almost all the aspects of the judicial accountability. Thank you very much for your nice presentation. Do you think, sir? Just I would like to just know. It is not my query because we are colleagues. So just I would like to know your view that whenever you are talking about the declaration of the assets of the judges, according to a 2025 report, April 2025 report, only 12% of the judges of the High Court in India have actually declared their assets. Now we don't know what they are doing, what is their source of income, whether they are earning from elsewhere also, maybe, who knows. So whether this declaration of the assets by the judges can be made compulsory, can there be any sort of mechanism through which we can make it compulsory? I mean, it's a kind of actually statement or kind of guideline which is given by the Supreme Court. Supreme Court has asked it. But only 12% have actually disclosed their assets. So will it be possible to find out who possesses what kind of assets in India? Possible, right, Yogi sir?
It is compulsory as a citizen of this country and who uphold such seats, uphold such during that time according to such rules regulation. If judges are not follow these rules and they have not declared their asset during that time, if they given such judgment, how can the asset of the people of this nation? So there must be highly essential when they taking such seat during that time they must declare their asset according to that law. But why they are not declare their asset? That is question mark.
Thank you, sir. Thank you, sir, for your observation. I'd like to call upon the next presenter. Thank you very much for your time.
Thank you, all of you.
Next paper presenter will be, I think, Bhagyavati Behra. Is she present?
Yes, sir.
Bhagyavati Behra?
Yes.
Yes.
Just wait. Come steady, Joe.
Very good afternoon to the session chair and the reputer of this session, respected teachers and my dear friends. My name is Bhagyavati Behra. I am a student of Ganjam Law College, LLB 6th semester. Now, I am going to present my topic, backlog pendency of cases in India. It is a very important topic because it is related to the justice, people's trust in judiciary. Before I am coming particular topic, I will speak some few lines of judicial accountability. Is the main theme of this seminar. Judicial accountability. Judicial accountability means response of judges followed by law, transparently, honestly, and fairly. Current framework of judicial accountability in India. Constitutional impeachment process, Judges Act 1968, in-house mechanism, standard ethical standard of principles, and contempt of court. Now I will discuss backlog pendency of cases in India. Backlog pendency of cases means a large number of pending or undecided cases in court without final judgment. The problem exists in High Court, Supreme Court, District Court, and subordinate court. sometimes people feel that judiciary is not working well, and you this delay the judiciary justice, delay the justice. Current status of backlog pendency of cases. India faced a large number of pendency of cases. District and subordinate court also have a large number of pendency of cases. The in 2000, the district and subordinate court have a now five in all India combined courts. The 5 crore or 50 million cases are pending in 2025 data, and High Court also faced a large number of pendency cases. In 60 lakh cases are pending in 2025 data, and Supreme Court of India have also pending a large number of pendency cases, and 88,000 to 90,000 cases are pending in 2025 data. Because justice is delayed. One legal principle is explained, justice delayed is justice denied. It's clearly explained that the biggest issue or problem of the pendency of cases in India. Why the backlog pendency is still high? The shortage of judges, procedural delay, lack infrastructure, and increase in litigation, and weak case management, and delay the police investigation and prosecution. Article 21. Article 21 also states that the right to life, personal liberty. The Supreme Court held that also include right to speedy justice and the speedy trial. And Article 39A answer states that the free legal aid and equal justice, and Article 39A answer states that the free legal aid equal justice. The pending of the large number of cases in a long period in court, the vulnerable people suffered and goes against the 39A. Article 50. Article 50 answer states that the independent judiciary. The independent judiciary must be efficient and accessible. But delay the justice, and the people trust, we can trust in a judicial system. One relevant case law, Vishwanath Khatun versus State of Bihar 1979. It is the landmark cases, and the Supreme Court held that the delay the trial is the amount of the deny the justice, and the right to speedy justice and speedy trial is the right to the fundamental right of a person is the related to the personal life and personal liberty, and the delay the justice and delay the trial is the violation of the Article 21. Impact of judicial backlog pendency of cases. Delay the justice is deny the justice. The delay the justice and delay the trial is the public confidence reduces, and weaken the public trust in the judiciary, and at the violation of the Article 21, and sometimes accused remain in jail long period without conviction, and innocent persons are also suffered, and business matters, the property related issues, matters, and dispute business matters are a long period pending in the cases in court without final judgment. Then parties are required to spend money and the court fees and lawyer fees and other expenses. The increase the financial burden and the affect the economic growth. Sometimes they delay the punishment. The criminals do not fear the law and encourage the crime in society. Steps taken by the judicial reforms, e-court facilities, and local adalat area, and the special court, time-bound disposal of cases, then more judges appointment. Now, now I would like to present my conclude summarizing the main point. Backlog of pendency cases is the very biggest problem and the issue of the Indian judiciary system. The delay the trial and delay the justice, so, reduce the public trust and reduce the public confidence, weaken the trust in the judicial system, and the violation of the Article 21. To solve this problem, the India need more judges appointments, fast track court, and better infrastructure, technology uses, effective of the judicial reforms. The judicial is meaningful only when the court given judgment without delay. Thank you.
Thank you. Thank you, Bhagavati Vera, for a nice presentation. You have presented very nicely regarding the pendency of the cases and how to overcome this pendency of the cases so as to strengthen our judicial system. Thank you very much for your nice presentation. I would like to call upon the next presenter. Thank you. So, Muhammad Sirajuddin Ansari. And there is another one, Sriya Chandana Sahu. Are you presenting together? Reducing tendency of backlog cases, challenges and solutions.
Sir, Shreya.
Both are different?
Shreya.
Okay. Okay. Sriya Chandana Sahu. Okay.
Next up, please.
A very good afternoon to the respected chairperson, esteemed faculty members, and dear participants. I am Sriyachandana Sahu, and I am presenting on the paper Reducing Pendency of Backlog Cases, Challenges and Solutions. Behind every pendency of cases, there lies a human story of uncertainty, financial stress, and loss of faith in justice. Delay in justice has become one of the biggest challenges before the Indian judiciary today. Justice should be fair and also fast, but today many cases take years to finish. This delay creates a serious problem called pendency of cases. So when justice is delayed, people not only lose faith in courts, but also in the rule of law. Reducing pendency of backlog cases, what it actually means. Reducing pendency of backlog cases means why courts have too many pending cases, what problem this delay creates, and what practical steps can reduce this delay. Chief Justice of India's view. The seriousness of delay in justice has also been strongly acknowledged by the highest judiciary. Recently, at the Farid Aliman Memorial Lecture, that is on 24th January 2026, the Chief Justice of India, Justice Suryakant, made a powerful observation. He stated that justice delayed is not only justice denied, but it is justice destroyed. It means that justice itself is lost when people wait for years or even decades to get justice. So, reducing pendency is not just an administrative issue, but a constitutional and moral responsibility. Challenges. The main reason for case backlog are huge number of cases. India has a large population. Disputes related to land, family, and crime are increasing. For example, a small property-related dispute between two brothers goes to court and continue for years because similar cases are already pending. Then comes shortage of judges. Number of judges is less compared to number of cases. One judge handles hundreds of cases at a time. For example, if one doctor treats 1,000 patients alone, then the treatment will be slow. Same happens when court have fewer judges. Then comes frequent adjournments. Repeated postponements slow down the trials. Lawyers and parties ask for time. For example, a case fixed for hearing today get postponed to next month, then after next year, causing unnecessary delay. The problems of backlog cases can be reduced by increasing number of judges, reduces burden for judge, ensures faster disposal. The use of technology like e-filing and virtual hearing save times. It also improves transparency. Alternative dispute resolution. Keep minor dispute out of court. It is faster and economical. In the Hussain Ara Khatun v. the State of Bihar 1979 case, in this case, the Supreme Court held that speedy trial is a fundamental right under Article 21 of the Constitution. The court also observed that keeping people in jail for years without trial is a violation of their fundamental rights. So, justice delayed weakens democracy. Justice destroyed, justice destroyed damages society. So, reducing pendency is not just a choice; it is our sad duty. Thank you.
Shreya Chandana Sahu, for your nice deliberation. You have highlighted various dimensions regarding the pendency of the backlog cases and the solutions. Also, you have given some of the solutions. Thank you very much. I'd like to call upon the online paper presenters if they are present. Disa Jasmine A. You can connect and call one by one.
Yes, connected, sir.
Are you there, madam? Jasmine A. Am I audible? Yes, madam. You go ahead. You can go ahead with your presentation. You can start.
No.
Yes, it is visible. You can start presenting.
year also.
Thank you, Justin, for your nice deliberation. And you have highlighted some of the key aspects of the plea bargaining so as to achieve the timely justice and how to reduce the actually prison inmates numbers in India. And it is indeed a very crucial issue where actually there is overcrowding in our prison, especially of the underground prisoners. And starting from Hussain and Khatun to all other attempts, judicial attempts, or be it other attempts also. But one of the key aspects is the plea bargaining. And I would like to know what are the actually limitations of the plea bargaining as a tool to reduce the actually number of the inmates or the prison population, whatever is there. What are the limitations of this particular plea bargaining? Thank you very much, Mr. Jasmine, for your nice deliberation. I'd like to call upon the next presenter. Thank you very much. Dipti Odhikari is the present.
Yes, Titya Adhikari.
Dipti Odhikari, you can start your presentation. Are you there in the Google Meet?
Titi.
Yes, yes, you can start your presentation. Dipti Odhikari. Yes, yes, yes. Yes, it is visible. Go ahead.
Mana?
Yes, go ahead, go ahead. Your slides are visible. Okay. Thank you very much, Dikti Adhikari, for your nice deliberation. Indeed, you have presented it very nicely, and your topic is also quite innovative. And thank you very much for your presentation. I would like to call upon the next paper presenter. It's Mr. Vaibhava Mohanty. Is he present?
Got you. Joe.
Yes, yes, go ahead. Go ahead. Due to scarcity of the time, I have to request the representatives to see the findings, go to the findings and conclusion. We know about the tendency of the judicial tendency and all. Basic concept you can skip. You can go to the findings and the suggestions and conclusion. Okay? That will be. Thank you for your nice deliberation. Indeed, you have highlighted some of the key aspects of the pendency of the backlog cases and how to overcome it. You have talked about the AI tools also. Thank you very much. I think it is one of the innovative paper we have come across in this session. Thank you very much for your presentation. I would like to call upon the next paper presenter, S.K. Nasir.
Yes, sir.
Is he present? S.K. Nasir.
Yes, yes, sir.
Are you there? If there is no, I think Sulabha Pradhan.
Sir,
Is he there?
sir, absence.
He or she?
Sula Pradhan absence.
Sulabha Pradhan.
Absence.
Absent. Okay.
Sir, SK. One second. SK Nasir.
So we'd like to take up another fine presentation. Sarita Behra and Angelina Behra. If you are there, you can come and present. I think this will be the last presentation of this technical session. Thereafter, we will proceed to the next, whatever the committee decides.
Yes.
We can wind up this next session.
Good afternoon, respected faculty and fellow students. We are Angelina Behra and Sarika Behra from Department of Law, BJP Autonomous College. We feel honored to have been given the opportunity to present our research paper titled Judicial Activism vis-a-vis Judicial Restraint, striking the right balance in ensuring judicial accountability. It addresses a critical dilemma in the Indian legal system. In a country where judiciary is an independent constitutional watchdog, we must ask ourselves, how do we ensure this watchdog doesn't become a despot? We often see a tug of pull between the parliament's legislative power and the court's power of judicial review, as had happened in the era between 1967 and 1980. Specifically, surrounding the Golaknath 1967, Keshavananda Bharti 1973, Minerva Mills 1980 cases. Best represents the intense power struggle between the Indian history and the Supreme Court. Our study focuses on the central problem when activism becomes excessive. It risks regarding democratic legitimacy by allowing judges essentially create law from the bench. Moving on to the next slide. To understand the middle part, we must first define both the terms. Both judicial activism and judicial restraint share a common ancestor, the power of judicial review. The power is firmly rooted in Article 32 and 226, which allow the Supreme Court and High Courts to review the state action, and Article 32, which allows them to strike down unconstitutional legislation. When we talk about judicial activism, we are referring a proactive philosophy, as we define it in Wharton's Law Dictionary. It occurs when judges allow their views on public policy to guide their decisions, often moving past established precedents to promote social justice. It is a philosophy that treats Constitution as a living document instead of treating it as a rigid set of rules. On the other side, the scale is judicial restraint. This is a procedural doctrine urging judges to refrain from legislation from the bench. It demands substantial difference to the elected legislature executing intervening only when there is a clear, valiant, and violation of the Constitution. Under this approach, the court acts as a neutral arbiter rather than a policy-making body. The Act of Restraint serves as a necessary balance of judicial intervention in public policy to ensure that the laws of the land are framed by those interpreting the general will of rights. Moving on to the next slide. The struggle between activism and restraint isn't new. It has a history that began with U.S. Supreme Court. In the landmark 1803 case of Macquarie versus Madison, President Thomas Jefferson ordered Secretary of State James Madison to withhold commission of William Marbury, who was appointed a justice of the peace by previous administration. The court found that while Marbury entitled to his commission, it couldn't force Madison to deliver it because the act of Congress authorizing the lawsuit was unconstitutional. Chief Justice Marshall declared that the Constitution is the supreme law and any legislation violating it may struck down, introducing the doctrine of judicial review. India embraced this principle only on the Sankari Prasad case of 1951, processing strict restraint of support nation building. This changed dramatically after the emergency era. The Supreme Court took the chance, gave a new activist definition to Article 21, expanding its scope from procedure established by law to include US concept of due process of law. In the case Maneka Gandhi versus Union of India, 1978. Since then, we have seen a steady expansion of judicial power in cases like Vishal Tiwari versus Union of India, wherein the court asserted its right to review specialized policies to protect fundamental rights. This evolution, while the power established, the scope of the power constantly grew. Moving on to the next slide. To truly understand the tension between activism and restraint, we must return to the doctrine of separation of powers. As Montesquieu argued, liberty cannot exist when the judicial power is not separated from the legislative and executive. in our parliamentary system, where the line between the executive and the legislature often blurs, and the independent judiciary is not a luxury, it is the final watchdog. The challenge arises when activism involves what we call judicial legislation. While we celebrate the code for safeguarding rights, we must avoid absolutism. Similarly, in the case of Tamil Nadu versus Governor of
I'd like to interrupt a little bit. Sarita Vera and Angelina Vera, try to conclude suggestion and conclusion. If you have suggestion, you can put forward or you can conclude.
Sir, may we take a chance to explain the phases of the evolution?
Pages, not required. You go to the suggestions if you have. If you have written suggestion, if you have not written, go to conclusion. No problem. No problem.
As we conclude, we must reflect on the paradox of power that defines our legal system. The judiciary faces a constant tug of war. It must remain independent enough to check the state's power while remaining restrained enough to respect the democratic separation of powers. History has shown us the dangers of both extremes. The emergency era of 1975 to 1977 serves as a stark reminder that extreme judicial restraint can lead to a failure in protecting fundamental civil liberties, as seen in the ADM Jabakur case. However, ultimately the strength of our constitution relies on judicial discipline. Legitimacy does not flow from the possession of power, but from its restraint and responsible exercise. As we look forward, the judiciary must vigorously protect the basic structure while strictly self-regulating its own boundaries. Thank you very much for giving us the opportunity.
Thank you very much for your nice deliberation, Sarita Behra and Angelina Behra. Actually, I just this reminds you of seeing you people. Actually, I want to go to the flex back. Actually, I was in it was in 2012, 13. In those days, I used to be a student. So I used to present papers in various national seminars and all. But seeing you being a LLB student, BLLB student, presenting papers, very nice to see you. Appreciate your endeavor. I would like to congratulate all the presenters of the vote technical session. I think with your presentation, we have concluded successfully the vote technical session. So thank you very much. Over to the reporter for the presentation or whatever you have. Thank you very much.
Good afternoon. Now I would like to present the rapporteur report. In this technical session, 16 research papers have been presented by various presenters from across the country. The session witnessed active participation from academicians, researchers, and students presenting papers in both offline and online mode. In the first segment of the session, the presenters examined comparative models of judicial accountability and the role of transparency in strengthening public trust. Further, the session is enriched by examining comparative judicial accountability in India and the UK, environmental adjudication, and the broader role of activism in advancing justice. The second segment of the session focused on the pressing issue of judicial backlog and systemic delays. Presenters identified key causes of pendency, including judicial vacancies, procedural delays, and infrastructural limitations. With this, I would like to conclude my report. Thank you.
Good afternoon, everybody. Thank you so much, Dr. Gogoi. And thank you very much, Dr. Barua, for presenting the report of 16 presenters, seminarians across this country. And also, our organizing team, we extend collectively our heartfelt gratitude to Dr. Chittaranjan Gogoi for being here, and he took out his time, valuable time, and gave us out of his busy schedule. Also, I would now like to request our convener, Manoj sir, to felicitate Dr. Chittaranjan Gogoi with a memento as a mark of honor and connection with him for his beautiful insights. May I request the audience to give him a huge round of applause and also a standing ovation. Thank you very much, sir. Thank you very much. We request Dr. Barua ma'am to join him. Yes. Come on, everybody, have a huge round of applause for both of them. Sir, we are deeply honored and graceful and blissful to have you, sir. And we would love to have you both again and again in such programs. Okay, everyone, I request you all to settle down. Kindly be seated. Please be seated. Have we all settled?
Yeah, sure.
May I start?
Yes.
Okay. Thanks, everyone. So once again, good afternoon to everybody present here, in and out. True judicial independency is not a shield to protect wrongdoing, but an instrument to secure the fulfillment of constitutional values, said by our former CJI, Chief Justice of India, T.Y. Chandrachud. Dear ladies and gentlemen, now we have reached at the last part of our technical session of this 2 days national seminar on judicial accountability. And now, let me introduce you all with the session chair, with the honorable session chair of the 6th part of technical session. The session chair has completed 3 master's degree, one in MBA, the second in MSc, and the other one in IT. Our session chair is a master diploma in software engineering. Sir has qualified NET examination 4 times. First, in the order of law, management, labor welfare, and HRM, IKS, Indian Knowledge System. Furthermore, he has completed maximum number of courses from the SWAM platform, 72 courses in Odisha. And some of the courses, for some of the courses, he topped the All India examination. And he has also participated in more than 100 of seminars across this country and internationally also. He has also been a part of different workshops, both national and international reviewed. Sir has translated a book, and the book is entitled as Energy, Economics and Policy into Odia. From English to Odia, he has translated. And our sir, our honorable session chair, is also a regular article writer, both in English and Odia language in daily newspaper. And any guesses? Who is he? He is the most simplest person with the highest qualification, and today
when I went to him and asked him, "So kindly extend some biography of yours such that I can read it out and let the audience know, because maximum of you are from outside. People won't know unless and until I speak about you." Sir, as he started, he said, "Kichi nahi bas kohi to wo, I am a very loving teacher, a very simple man with the most outstanding performance." And when he started, as I was noting it down in my file, I said, "Sir, please, I'm going to faint. Sir, please, I'm going to faint." So are his designations. So, with due respect and honor, without delaying much, lovely audience out there, have a huge round of applause for our session chair. He is none other than Sri Loknath Patra, sir. And also, I would add, sir is pursuing his PhD degree in law under Parampur University. Sir, I request you kindly adorn the chair. And you will also act as the rapporteur of this session. Over to you, sir. By the way, the audience would agree with me, sir, you are looking so dashing today.
Thank you so much for your kind words. Actually, whatever you have described, I'm not that much. I'm a very ordinary person like you people. Okay. It is my passion, like the achievements that I have done. So this is all my passion because I give maximum time in studying. I study different subjects and I also write articles in different topics. So you might be seeing in different news articles also. But anyway, that's a thing. In this session, we are going to discuss about this is the sixth theme, future reforms for strengthening judicial accountability in India. So, as we have already gone through 5 different themes, which all are dealing with judicial activism, we have seen the role of technology, the role of media, and a lot of deliberations are already done, isn't it? So now, the last one usually we come to a kind of conclusion kind of topic, and this topic basically talks about what kind of reforms we want, and actually what kind of reforms are undergoing. So in this, we may have some comparisons also. We can compare with some of the leading countries. Okay, that also can be done. So I would like to call upon the first paper presenter. And the rule everyone knows, they have to present in 5 minutes. Okay, within 5 minutes we'll complete. And the first paper presenter is, I think one was left out in the previous session, so I'll call them up. Sarita Behera and Angelina Behera. That's done. So nobody is left now, so we can start with this one. Okay. So the first participant, Kumari Bhavna, and her topic is future reforms for strengthening judicial accountability in India. So I would like everyone to please give a big hand for her. She is the first speaker in this. Okay. So please.
Liêu. Đây là Liêu.
Good afternoon, images. I'm Kumari Bhavna from Ganjam Law College, third year. So today my topic is future reforms for strengthening judicial accountability in India.
Right.
Um, to remain a people's code, it must evolve from a closed loop system to one that is open and answerable set of mechanisms, making judges and courts personally or institutionally responsible for its behavior and decision. Contrary to constitutional or legal standards. They are answerable. They are answerable to people of India, our country. Here are some reforms which should be done in some sectors, like the collegial system, mostly, um, implementing merit-based judicial appointment system by conducting all India Judicial Service, unlike IAS and other public services, by governing by National Judicial Appointment Commission, already introduced in 2014. However, it was withheld in 2015. While striking down the NJSC, the court acknowledged the need to improve the collegium's efficiency through a revised memorandum of procedure. Conduct of judges. A more formal and comprehensive code of conduct for judges, which should be enforceable by law. To avoid corruption, judges must disclose assets in periodic basis. Judges are concerned about post-retirement job postings. Also, removal process of judges, if needed, by parliamentary impeachment. Now, information symmetry. It means to maintain transparency, actually judiciary kept itself out from ambit of RTI. To reduce opacity and maintain transparency, it must kept in ambit of RTI. By using technology, our Guggen sir said to use technology where necessary. So I agree with him, and the necessary use of technology must be done. So, by the use of technology uh, in virtual court expansion, blockchain for secure record maintenance, online grievance procedural portals, and the most important thing is digital training for judicial officers to do all the technical things. So we know justice is done in courts. The thing is for a common people or the rural people who are some have the financial criteria is very low financial criteria. The poor people who are who are willing to approach court, but due to financial limitation, they don't usually they don't approach. So inexpensive justice, which will promote justice that is affordable, accessible, and efficient for people, ensures no citizen is denied justice due to financial constraints. It will promote equality before law. And the topic I relate, that is language and accessibility. Nowadays, we know the proceedings and judgments are in mostly in English. Some people they don't understand, they may not understand English. So judgment in regional language for a common people, proceedings in regional language, and training judicial officers in regional language, free interpretation for litigants, use of layman languages for judgment and court proceedings. That will help people, common people. So, to maintain public trust in judiciary and democracy, a more formal and comprehensive code of conduct for judges which should be enforceable by law. That's very important point. In past years, Odisha High Court became the first to publish performance and working annual reports. Thank you.
Thank you so much, Bhavana. Your ideas are very good. I will just uh, put light on two things. One is in the previous slide you have mentioned about the judiciary. They think of after jobs. Like most of the chief justices or justice in Supreme Court, High Court, they usually get a very good post, either a government post or in the political system, and that, isn't it? So that may be one of the bias. They are in favor of the government, isn't it? Do you think this? Okay. So do you think anything can be done for that? Yes.
Please repeat.
Yeah. Any criteria or anything should be done so that this kind of bias won't happen.
Because they have pre what can I say?
Yes.
Pre-decided posts.
Yes.
So they are ensured of this,
Okay.
these posts and things.
Yes.
So actually now I don't have idea,
Okay.
but I wish to.
Okay, one more thing, you have put a very good thing regarding the regional language translation. Okay, now softwares have come up, even the Supreme Court and High Courts, they have started translating into regional languages. And another important thing I would like to say here is, like, people afraid of court because they are afraid of the language of the court, because the legal jargon they do not understand. But now, even the judiciary are coming up with new rules where the simple language can be put. Suppose you are filing something, so you can file with a simple language, like the language that you know, the simple English, simple grammatical English. That is also coming up now. Okay, new rules are coming up in that. Okay. Anyway, thank you so much. Thank you, Varna.
Thank you.
And now I would like to request Smritimay Barik and Swapna Rani Pradhan. Are they there? Please come and please.
Forward before. Forward before.
A very good afternoon to all respected panelists, respected teachers, respected seniors, and my dear friends. I, Smritimay Barik, with my co-author Swapna Rani Pradhan, we are going to present a paper on judicial accountability as a pillar of public trust, future reform perspectives. In every constitutional democracy, the judiciary derives its authority not from military power or financial control, but from public confidence. The judiciary survives on trust. when citizens approach courts, they do so believing that justice will be delivered impartially and fairly. Judicial independence is undeniable, the backbone of constitutional governance. It protects judges from executive or legislative interference and ensures decisions are made without fear and favor. However, independence without accountability can create institutional opacity. Therefore, accountability and independence are not opposing forces. They are complementary constitutional principles. In India, the constitutional framework reflects this balance. Articles 124 clause 4 and Article 270 of the Constitution provide for impeachment of Supreme Court and High Court judges on grounds of proved misbehavior or incapacity. However, impeachment is an extraordinary remedy and has rarely been successfully invoked. This raises an important are exist to sustain public trust. The Supreme Court in K. Veeraswamy versus Union of investigations, though procedural safeguards are necessary. This judgment established that judicial office does not place an individual above the law. Similarly, in C. Ravichandran Iyer versus Justice A. M. Bhattacharjee, the court emphasized that public confidence in the judiciary depends upon the integrity and conduct of judges. This case recognized that ethical accountability is inseparable from judiciary legitimacy. Thus, constitutional morality requires that judicial power must be exercised transparently and responsibly. I would like to invite my co-author to explain the rest.
One more minute is there.
Thank you, Shruti. In recent years, debate on judicial accountability have intensified, particularly concerning judicial appointments and institutional transparency. The landmark judgment in the Supreme Court advocates on record of Association versus Union of India, based on a popularly known as the NJSC case, struck down the National Judicial Appointments Commission Act on the ground that it violated the basic structure by affecting judicial independence. While the decision preserved the judicial primacy, it also triggered public discourse about the transparency in the collegiate system. Further campaigning for judicial accountability and reforms versus the Union of India, concerns were raised regarding the institutional mechanisms for addressing complaints against sitting judges. For the court offers a procedural safeguards, the cases exposed on limitations in existing accountability structures. These developments reveal several challenges. Opaque appointment procedures, the limited disciplinary mechanisms beyond impeachment, case backlogs affecting public perception, then institutional resistance to structural external oversight. Comparatively, countries like the United Kingdom and the United States are independent judicial conduct bodies functioning within statutory frameworks. These models demonstrate that accountability can coexist with independence when properly structured. Therefore, a purpose for following reform perspectives establish of a constitutionally safeguarded judicial oversight commission, then transparent application of appointment criteria, then statutory codification of judicial ethics.
Okay, come to conclusion now. Come to conclusion. Your time is over.
My friend and me, we conclude that carefully designed reforms rooted in constitutional safeguards can harmonize autonomy with responsibility, strengthening accountability mechanisms with the enforcement of the rule, democratic governance and international credibility. Thank you. Once again, thank you.
Okay, there is one thing I would like to know when you spoke about this impeachment process. Okay. So everything is there in the constitution, isn't it? But how far this is done in India? How many cases you have found such cases where judges are impeached in the through parliament? No. Okay, thank you. Yeah. So now we have participants in online. So I'll just read out the names who need to present online. Okay. Neha R. Kachi, Yamuna Hegde, Archana Mishra and Dr. Ansuman Mahabatra. Then we have Khan Amarullah, then Richa Jana, then Anisha Sama, Anshita Sama, then we have Aritra Acharya, Kishore Kumar Behra, Ankita Das. Are they online? So I'll start with the first participant online, Neha. Neha R.
कौन करिए Yes.
Carry on, madam.
Yes.
Madam, madam already. Madam, madam, sorry to interrupt you. You have already lost 6 minutes, so kindly come to the conclusion. Madam, it is already 6 minutes. I think you should come to the conclusion now because already other participants.
Professor, assistant professor. Judicial. Yeah, professor.
Okay, thank you so much, madam. First of all, I appreciate your PPT is designed so nicely. As your topic says architecture, judicial accountability, and the theme of your PPT also as a architecture, it's so nice. And I would request you to, if possible, kindly share your PPT in the group. Everyone will be benefited out of this. It's really very nice. Thank you so much. Uh, I would now request the next participant, Yamuna Hacke, available. Okay, please. And madam, within 5 minutes.
Yeah, yeah. Please hold this.
Yes. Yes. So thank you so much, madam. You have nicely presented your topic. So thank you so much. We have to proceed with the next participant. I hope Dr. Ansuman Mahapatra is online. Yes, yes, your voice is on. Yeah, it's visible. Thank you so much, Dr. Mohammed. You have elaborated very nicely. Your topic itself is quite diverse in nature because you have covered NEP 2020, Atmanirbharta, sustainable development, and lot of things. And we really appreciate your empirical study because your study caters to different sectors and different places. And as you mentioned, the first thing like the Indian knowledge system, like in India, whatever law knowledge we are giving, it is mostly theoretical. That I appreciate. And the recommendations also, whatever we have said, like the internship facilities which are there in other countries, so which is more practical oriented, that must be there. So all your recommendations are really great, and we wish that all these recommendations, if possible, will forward it. And one more thing, if you could present your PPT in a laptop or computer, probably it would be more visible because you have presented in mobile. So the letters were quite small. But anyway, your presentation is very nice. Thank you. Thank you so much. And our next presenter in online, uh, Amar, Amarullah Khan. Okay. Thank you so much, madam, for your beautiful presentation. It's really very nice. So I would like to go to. Okay. Next participant is Richa Janna. Are you online? Okay, please continue. Try to complete in 5 minutes. Yeah, you are audible and your PPT is also visible. thank you, Richard. Your presentation is really very nice. Thank you so much. I would like to request Ankita Das online, the fourth pillar and the gavel, role of media in strengthening judicial accountability and public trust. Are you there? Yes, Ankita, you can start presenting.
Answer.
Yes, yes, you are audible. Completing 3 minutes, we are running short of time because valedictory session has to start. So completing 3 minutes. Okay, okay. Thank you, Ankita, for your presentation. Thank you so much. Uh, Next, Aritra Acharya is there. Aritra Acharya online, not there. Okay. I would like to request now Kishore Kumar Behra. Are you there? Okay. Sir, complete it in 5 minutes.
The respected chairperson, dignitaries, the participants, the media persons, I am Kishore Kumar Behra, former principal of Government Science and Subject, and quite fortunate and delighted enough to deliver my topic entitled Judicial Accountability, a study of people's ombudsman before the intellectuals and dignitaries. My topic can be divided into 5 parts. First part deals with the separation of powers and checks and balances in order to point out how judiciary has become more powerful than the 2 organs of the government. Second part consists of that is judicial accountability to highlight the faulty procedure adopted by the government under the Judicial Inquiry Act 1968. Then third, that is deals with the failure of the impeachment procedure on the part of Parliament and judiciary. And last but not least, that is about people's ombudsman, which is highly essential. This shows how restatement of the values of the judicial life is essential, and a judicial accountability first December 2010, and role of civil society, role of media, NGO, amendment of contempt code of law, all these things are highly essential. In the accompanying letter, I will find in my paper, actually, can you show this judicial accountability and the ivory power to oversight. That is, then once Jawaharlal Nehru said that judges of Supreme Court sit on the ivory chair removed from the ordinary man who know nothing about them. So my topic entitled, I can briefly say, that is ivory power to public oversight. There is lacuna. I told you every organ is checked by other organ of the government. Judiciary is checked by and also executive, and executive is checked by judiciary and vice versa. And I will tell you how judiciary is checked by other organs of the government. Judiciary is checked by other organs that they are accountable to the parliament, legislature, because on the basis of the Judicial Inquiry Act 1968, it provides you the judges of the Supreme Court or High Court can be removed on the ground of proved misbehavior or incapacity. So here the Judicial Inquiry Act says that if the impeachment process or removal process starts from Lok Sabha, that minimum 100 members are required to initiate, and that will be handed over to the Speaker. And if it starts from Rajya Sabha, that the 50 members are required to present the charge sheet to the Vice President or chairperson of the Rajya Sabha. And there will be a committee. There will be a committee that consists of only, my point is, 3 only judges. The actual judges, I told you, the close brotherhood of oversight. The Chief Justice of Supreme Court and second member, that is a Chief Justice of High Court, and third was the district jurist. So in this connection, there is a faulty procedure. I say this faulty procedure is adopted. So my point here, that is, I would like to tell you. So why judicial accountability is necessary? It is necessary because it promotes the rule of law by determining the conduct. Second, that it promotes public confidence in judges and judiciary. And third, it promotes institutional responsibility by rendering judiciary responsive to the needs of the public. But the thing is, there is a lack of accountability of judges. Who will judge the judges? There is a question mark. So that will be solved by the faulty procedure. I will tell you the 3 in my the slide you will find there is an inquiry committee consists only the judges leading to perceived insincerity, and there are so many examples we find in our constitutional history. First impeachment case that was done in the year 1993 May. Justice Ramaswamy's case. Actually, though the committee found guilty by the inquiry committee, but the Congress refused to pass it off because there is a nexus between the parliamentarians and the executives, means ministers, between the nexus between judiciary and parliament, legislature and executive. We say that separation powers are there, but the point is separation power in reality there is no separation power. Checks and balances. We find there is a nexus between the parliamentarians and the ministers, or can say the executives. Second case is Justice Bala. You find there is a astonishing fact that Justice Bala, BJP declined to sign LK Advani case. That is because LK Advani was acquitted by Justice Bala in the Bombay versus case. Second, third, Paul Daniel Dinagara, the Chief Justice Karnataka High Court in the year 2010. Before committee was constituted, the complete investigation and submit report, PD Dinakaram submitted his resignation to the president, addressing the president. So you see the thing before the impeachment ends, before that submitted resignation to the president. Then Justice Soumitra Sen, after High Court, 2011. So Rajya Sabha voted in favor of the impeachment. When the motion for removal was to come up in the Lok Sabha, Justice Sen sent his resignation letter to the President of India before proceeding could begin in Lok Sabha. Then the most important, the present context in the March 2025, Justice Verma, you know very well, actually Lok Sabha Speaker constituted the committee, three-member committee, but as for the Justice Inquiry Act, but in the thing is Justice Verma challenged the in-house committee. According to Justice Verma, the committee was not constituted as per the Inquiry Act because the thing is, so in the concluding that is the most important part. So from my view, the people's ombudsman is highly essential in order to make the judiciary accountable. The first one is a restatement values of conduct, judicial conduct of life. The second one, judicial standard and accountability bill, not this to be passed in the parliament, and that is a I will tell you, 5-member committee will be appointed, can be appointed by the president. Here the recommendation of president is bound to accept the prime minister's committee. The second one, there should be alert civil society. Civil society is very much important. I know very well that the eternal vigilance is the price of liberty. So civil society should be alert, and in order to because the common man is the main consumer of all judicial decisions. They have the right to clean the judiciary. The civil society can take several campaigns against corruption and judicial accountability. And that is, in case of most of the presenters, they have given the examples like UK and also America and also Canada. But I don't want to explain all the things because of shortage of time. The role of media is also, and the media as well as the NGOs are highly essential in order to check the judicial process. The last one is that there should be amendment about judicial contempt of court act. So in the concluding election, I can say the three organs need to maintain coordination, cooperation among themselves so as to run the administration so smoothly. Certain guidelines for the judiciary are required to follow. So my point is that the judiciary, the accountability is questionable. The main task of judiciary to provide free and speedy justice. Then it is the organ that protects the public, and the public can acknowledge its accountability.
Okay.
So
thank you, sir. Thank you so much, time is running, sir. But anyway, I don't know whether you are from law background or not. But you have narrated it very nicely. You have presented the situation very beautifully. And I am fortunate enough that I belong to Science College, Chhatrapur. I passed in 1989 plus 2 science from that college. So I really feel very great about it that being a former principal, you are here. Okay, thank you so much, sir. Thank you. Next participant, Vaikuntha Behera. And the presenters need not be worried about the crowd. We have a crowd of hundreds of people because we are on YouTube live. So many are witnessing us, and this will be recorded, and this is already recorded, and later on also we can forward it to our relatives, friends, so that they can also watch this. Okay, Vaikuntha Vera, only 4 minutes. Please try to complete it.
Thank you, sir. So, judicial accountant in India. The three organization of Indian government, legislature, the executive and judiciary performance three essential function of rule and making, rule application and rule and adjustment and respectively. The main principle of behind this formulation and separation of power which bring accountability, keep this government responsibility and this ever you are right and liberty and subverted independence of the judiciary. Independence is a work of rule of law for if law is be applied equal to citizenship in this court, then it is equal important that is judge shall be independent of applying law of judiciary. Decision the judge can be subject to and theorist and processual pressures for including society. Criminal of elements with independence of judiciary and recognized principles. Mona Sukhol has provided us with the history of judicial independence in United Kingdom of United States. The judicial accountability. Judicial accountability, in fact, independence of the judiciary simplified and accountability refers to taking responsibility for your action and decisions. It is generally when behind responsible to any external body from any institution of accountability to the principle of oneself of rather than to any authority with the power of punishment or correction. It since accountability is a fact of independence rule. This constitution has provided in Article 235 for the control of High Court, the judiciary independence. This provision of a affected to enforce by accountability. Thanks.
Thanks, thank you, Vaikuntha Babu. Very nice presentation. And today's last presenter is Amar Kumar Patra. So briefly, you present in 4 minutes.
Respected seminar chairperson और आपके डॉक्टर तिलोचन लेखा सर, organizing committee secretary sir, Loknath Patra sir, and our respected Ramo Shankar Das sir, ex-lecturer of the GLC, and our
come to the topic first. 3 more minutes.
Thank you, sir. Today, am going to speak about the topic seminar, future reforms for strengthening judicial accountability in India. How judicial has the vital responsibility in India. Sir, myself Amar Kumar Patra, GLC second year. First of all, I am to narrate the judicial accountability is a cornerstone of constitutional democracy according to Kapadia, the Justice of Supreme Court, ensuring that judicial functions with integrity, transparency, and public trust in India. While judicial independence has been strongly safeguarded, concerns regarding accountability, ethical conduct, and institutional transparency have increasingly come to the forefront. This seminar examines the need for future reforms for strengthen judicial accountability within the framework of the Supreme Court of India and the broader judicial system in harmony with the values enshrined in the Constitution. The study analyzes existing mechanisms such as impeachment procedure in House inquiries and judicial courts of conduct, highlighting the limitations in addressing delays, opacity, and limited public participation. It further explores the role of Parliament of India in setting effective legislative frameworks to enhance oversight without compromising judicial independence. In judicial accountability, it emphasizes the importance of balanced reforms, including the establishment of independent accountability bodies, transparent complaint redressal mechanisms, mandatory asset disclosures, and standard ethical standards. It also underscores the need for technological integration such as digital case management and public access to judicial information to promote openness and efficiency. By adopting global best practices and contextualizing within India's constitutional framework, the seminar aims to propose practical and sustainable reforms. Ultimately, the paper argues that strengthening judicial accountability is essential not only for preventing misuse of power but also for reinforcing public confidence in the justice delivery system. Through responsible reforms, India can ensure that its judiciary remains both independent and answerable, thereby upholding the rule of law and democratic governance. The main keywords of the judicial accountability is judicial independence, transparency, institutional reforms, ethical standards, and public trust. So, I am to speak a few words. The 2-day seminar managed by all laureates, but in a nutshell, the conclusion of future reforms must balance judicial independence with accountability by replacing the opaque collegium with a transparent merit-based commission. Key measures include enforcing strict code of conduct, establishing independent oversight, implementing a digital efficiency tools, and enabling public scrutinizing. Strengthening these mechanisms is essential to restore public trust, reduce case backlog, and ensure integrity.
Okay, thank you so much,
The
Honorable.
future judicial reforms in a 2-3 words. Let me transparent appointments, moving towards an independent mechanism for judicial appointment to replace the current system. Second one, The accountability mechanism establishing independent body to investigate complaints against judges and amending the Judges Inquiry Act 1968. Modernization and efficiency, utilizing technology, e-courts, and our artificial intelligence for further case management, in reducing pendency and increasing transparency in court proceedings. Ethical standards, we have to maintain the mandatory public trust through accountability, which is essential to maintain the judiciary role as a protector of constitutional rights.
Okay, thank you so much, Amar Babu. As we are in short of time, verdict session will start. Thank you so much. Now we are going to have a lunch break. Lunch break will be for 15 minutes. After that, we are going to start. Sir, Amar Babu, sir.
Today's signal will success if we all have to place reforms, transparent appointment, accountability mechanism, modern methods of ethical standards of the judicial system. Judicial system will strengthen the future democracy of India. Thank you to all.
Thank you all. We are going to have a break for 15 minutes. After 15 minutes, our chief guest, Pavitra Mohan Sarmal, Dr. Pavitra Mohan Sarmal, who is the Principal Secretary of Law Department. He is arriving now. Okay, once he arrives, so we'll start the verdict section. So there will be a break of 15 minutes. Thank you so much.
ସେଟା ବନ୍ଦ ହେଇଯିବ ଏଡିଟି ଛୁଇଁଦ ହେଲା ଏଡି ଛୁଇଁଦ ଖାଲି ସେଟା ବନ୍ଦ ହେଇଯିବ ଏଡି ଛୁଇଁଦ ଖାଲି ହେଲା
Chief guest ଙ୍କର totally sorry, 5 round ଅଛି।
नहीं चीफ गेस्ट पर वही नहीं गिफ्ट दी थी और उसे सर का कौन था ना कमलजीत सर चीफ पेट्रन और सेशन चेयर जति की पॉलिटिक्स के समस्त मोड सेशन चेयर हमें कोई कौन विनायक पटनायक सर हां मिसेस सुजाता पात्र
भाग्यश्री में राइट
रेडी इधर
प्लीज कम आ फोटो वॉलंटियर होते योने मिस यू नहीं प्रेजेंट कला वाले को उठा तापर मिस यू धरो कौन उड़ो ये पर अरे जिम्मी
कौन ଅଛି गाड़ी बनाए ग्लास बोतल लगा जाओ बाहर की पियन ଅଛନ୍ତି
कौन गया मु पियन ଅଛି कौन कौन listen अरे
से टिंगरी तमे याड बसना है देखा दो ना क्या चाकू असा कुछ क्या सा
चाकू ये गिरे सेट कर दिला रखियो तो कौन से तला କହିଥିଲେ ଗୋଟେ କଥା
हाय मिस शॉट असना ये आपको क्या
इधर साइड कौन कितना दे देना गारू पड़ नहीं घरू पड़ କିଛି ଅସୁବିଧା ନାହିଁ ଯେତେବେଳେ କହିଥିଲ ସେଇ ମେମୋରି ଯେତେବେଳେ କହିଥିଲେ ଏଇଟା ରଖିପାରିଲେ ନା
सेशन चेयर लागे प्रेजेंट गेस्ट
नहीं माइंड करे कोड टेक यार नहीं
आपको आंडियो बॉक्स नहीं था मूवमेंट नहीं था
वीडियो तक करना
एक्टिंग କରୁଛନ୍ତି नो
नहीं ତାଙ୍କୁ ଗୋଟେ ମେମୋରି ଦରକାର ଟିକେ listen देखो अपन दरकार में मत बोलिए
Pleasure anytime. તમે કોણ કોલેજ बीजेपी કરી ଏବେ ବି
ତମ ପାଇଁ ଠିକ
ଅଛି ଅଛି बीजेपी कॉलेज में पहले भी
हां ठीक है साड़ी पहन हां साड़ी पहन साड़ी का नंबर दो व्हाट्सएप पे कर दी
चलिए कौन करेगा इनविटेशन तक केमती देबे आप किछि नै हमको ईमेल कर दियौ हमर कॉलेज रो अछि लोकल प्रोफेसर आसीबे जेतिले जाक
768
और I can give you the email ID अपन हाँ सेमिनार कॉलेज ऑफिशियल सर्टिफिकेट नहीं था मैं बहुत सारे क्लासेस और मॉडल थे
पटन कॉल अछि तो बोल
बाहर को देला चिकी देले के जितेला सेटा हबो ना साउंड सुबियो तो ऑन करके देखो ईच स्टूडेंट को ला रखा हबो सर्टिफिकेट से जो कलेक्शन करेंगे नहीं आप गेस्ट कॉलेज जो हम रिसीव करेंगे
Hello.
हाँ नाही आहे सर्टिफिकेट खाली फीडबॅक बाय डेलिगेट्स मॅडम सर्टिफिकेट डिस्ट्रीब्यूशन ଅଛି ସେଟା ଖାଲି ସେଟ୍ କଲେକ୍ଟ କରିଦେ ସେଟା मैडम 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 सर्टिफिकेट डिस्ट्रीब्यूशन में इनके हाथ में कुछ नहीं है सर्टिफिकेट डिस्ट्रीब्यूशन ये स्टूडेंट के लिए आपको दे रहे हैं ना हाँ यही पे अनाउंस करेंगे जीपीएस के से देंगे या फिर वहां से कलेक्ट कर लेंगे उनको दे देंगे हाँ ठीक है एक तो हजबन से हम नहीं अभी
राशि कौन
दिग्गज बड़ा आसी देखिए
दिन से ଏବେ ଅଛନ୍ତି equal to ନା ଓଡିଆରେ କହୁଛି
equal to IAS
IAS ନା କର ମ୍ୟାଡମ ପଚାର
ତାଠୁ ଉପର ଲେଭେଲ
IAS level
ନା IAS officer superior judicial officer ओ साथ लाइव देखियो तो मुझे तो बस पड़ियो
ଆପଣ देखिए ଏଇ
नाइस एडी तो साइड रे बस पड़ियो मैडम ज्वाइन
ग्रुप में ये कैसे गेस्ट है आउट है हां हां कोई एटीएम मतलब कि सुजाता sit is my relative
present to PPT. Present your PPT. I'm very proud and privileged
to stand here like that असली की मैडम नाले तक गोएंगे नहीं पता सब पे मीटिंग सिखाई नहीं तो पूरे पार्ट ये क्या अच्छी रे रिकॉर्डिंग रे
ଖାଇବା ହଉ ଯାଇ ଖାଇବା ଯାଇ ନମ୍ବର ଅଛି ହେଲା କର
say please come Jitendra Tripathi and please come Miss Gitanjali Datta. Miss Gitanjali Datta and Sergeant Mr. Jitendra Tripathi come to stage and Please decorum the silence. Side.
Copy. Mobile.
ଆମେ 2 ଇୟର୍ସ ଆମେ ଲୁଟି ବେଲେ ମର କେନା No, ଟିକେ ଆମ ଦି ଜଣ ଆସୁ ଦି ଜଣ ଟିକେ 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 ଗୋଟେ ଆମ ଫଟୋ ଟିକେ ଆଗୁ ଠିକ हां हां उठाओ
बाजी मोबाइल देखिए ମଟଟା ଭଲ ବାହାରି ଅଛି ନହେଲେ ଆଉ ପଇସା ଦିଟା ଧର ହେଇଛି
ତାପରେ ଆସ
ସବୁ ସେକ୍ରେଟାରୀ ଅନୁସାରେ ଆଉଛନ୍ତି ତ ସାର୍ଟିଫିକେଟ୍ ଦିଆ ସାର୍ଟିଫିକେଟ୍ ଦେଲେ ସର ଆମର ବ୍ଲକ ସେକ୍ରେଟାରୀ ପଳାଇ ନାଇଁ ପଳାଇ ଆଗ ରାସ୍ତା
मैडम के साथ
मीटिंग नहीं की
ଆଉ କହିବେ ଖାଲି ସେ ଚିଫ୍ କେସ୍ ଆସିବେ କହିବେ କହିକି ସାର୍ଟିଫିକେଟ୍ ଦେଇ ଲୋକ ପିଲା ଆଜି হবে 60 ଜଣ କାଲି 100 ଜଣ କାଲି 100 ଜଣ ଥିଲେ
May I have all of your attention, please? Please get ready. Chief guest, a warm welcome to our chief guest, our valedictory officer, Dr. Pavitra Mohan Samal sir, Principal Secretary, Law Department, Government of Odisha.
सर तो किसी काम नहीं मुझे फोन करा ऑनलाइन हो
Okay, have you all settled down?
लाइव डॉट क्लिक
We are waiting. Kindly be seated.
चल चल वीडियो वीडियो क्लिक
Good afternoon to one and all. Welcome back to the valedictory session. I hope you all must have enjoyed sumptuous lunch served at the portico. Welcome back again. So we are delighted and blessed to have amongst us Dr. Pavitra Mohan Samal. May I request my audience and our faculty members to give him a standing ovation. Also, I would request our friends to felicitate him with the bouquet, with the flowers. Namaste, sir. Welcome you to our national seminar. Sir, kindly adorn the chair.
ऑल लाइव तो वी आर ऑनलाइन ऑफ कर ली সেটা अपन
Yes, everybody. As we proceed with the valedictory ceremony, and as our chief guest of the day has already arrived and adorned the chair along with our convener and conference chair, let me introduce you all with Dr. Samal. Dr. Pavitra Mohan Samal is a prominent judicial officer in Odisha. As of late 2025, Dr. Samal was appointed to his current position as Principal Secretary, succeeding Manas Ranjan Barik. His career in the Odisha Superior Judicial Service includes several high-level roles. Principal Secretary to the Law Department, appointed in 2025 October, based in Bhubaneswar. Previously, he has also served as the District Judge for Balangir Sadar. He has formerly held administrative roles as a Registrar of National Law University Qatar and the Odisha High Court. Sir is recognized for being well versed in various branches of law and is often described as an impartial and soft spoken judicial officer. He belongs to the District Judge cadre and hails from the Gajpati district of Odisha. So, please join me to welcome and honor our chief guest of the day. And you will be delighted to know, my dear audience, Sir has also served as a nation builder in our institute. He had started his career as a teacher in our institute. So once again, welcome you, sir, to this your very own institution. I now would like to request, with due respect and honor, I would request Professor Dr. Vinayak Patnaik, Principal and Director of GLC, to kindly address this august gathering. Please, sir.
जय जगन्नाथ जय जगन्नाथ समस्त को मोर नमस्कार good afternoon to you all honorable chief guest of this valedictory ceremony Dr. Pavitra Mohan Samal the convener of the seminar Manoj Kumar Janasamanta, all the distinguished delegates to this conference, and this moment is very precious for all of us. The reason is that we are concluding whatever we have deliberated over the last 2 days. In our deliberation, the students have shown their intellectual capacity to the extent we expected. And I will say it was also in some papers beyond expectations. Anyway, I request that the seminar will be very meaningful to them and they will make use of the contributions which the seminar has made in their future career. The chief guest of this occasion is Dr. Pavitra Mohan Samal. I will not tell many things about him. I will tell only one thing, which is not related to his quantity but quality. As I have been observing him since the last 15 to 20 years, I have marked, from a student career, I have marked one thing. That one thing is his humility. Wheresoever he will see, whether he is a principal secretary or he will not miss to touch the feet of the teacher. And that is why he is here. Respect to the seniors, I learned from him. Forget about efficiency, honesty. Unless there is efficiency and honesty, you will not be placed as a principal secretary. That goes without saying. But this is the humility and the respect to the seniors are the assets of Pavitra Mohan Samal. And we are proud, privileged, and happy that he has been kind enough to accept our invitation and to be here today as a chief guest. I did not reiterate whatever happened because our another organizing secretary will narrate you the all proceedings of the seminar, but I will in a nutshell conclude the 6-7 points. My first point is regarding judicial activism, judicial review, judicial restraint. All these things are necessary. It is not incorporated in the constitution without having any reason. Judicial activism is nothing but filling up the space between the problem and the law. And when the legislature or executive I will not say fail, miss to create any law to solve a problem, then the judiciary develops a principle, not law. Please remember it. In many of the books I have seen, judicial activism is judicial creativity, creates a law. How judiciary can legislate? No, it is only legislature who will legislate. So we are using wrong words even in the books also. I say judiciary develops a principle to solve the problem. And that principle, if accepted by the legislature, it becomes a law. Then you will call it as a law. Whatever cases you take, a Joseph Sang case or transgender case, whatever cases that judicial activism we have seen, many of the cases, only Supreme Court develops a principle. That is the new thing which I am taking. The second thing is the judicial review. Let us sometimes, in one of the members of Congress, American Parliament says, once it will, the time will come, the judiciary of America will devour the Constitution. Why? It is because the Supreme Court has been so powerful that by the power of judicial review, any law which is passed by the Congress, they felt that it will be rejected. So why we will make a law? So then there was a saying, there was the one particular concept was developed. You will be just surprised to know they developed a concept of geometrics to assess the minds of the judges whether this law will be accepted by the judiciary or not accepted. This was the fear. But remember, in our nation that is not there. Our judiciary is very careful before striking any law. Very rarely that national judicial appointment जो होगा नहीं जो ये law को reject कर दिया, but very rarely does it. So that is the second point. Judicial state is nothing but judiciary only declares the law. So judiciary declares the law, reviews the law. If necessary, it creates a principle which is as good as a law to solve a problem. That's all. This is all about this activism, restraint, and review. My next point is I always want to say this media. As we are saying, media is only informative to the judiciary. They are we biased by the media? We are also thinking, so teach all code one said, we are let the media. We common man also say, media is about the other sort of them. A judge of the Supreme Court will also think that now it is final. This talk itself has no meaning. They give the information and that is okay. But without evidence, how can we punish any person? Because judges may take anything, but without evidence, no judgment can be taken. That is why without law, without evidence is important, people say. So that's why. So all these things, they may invoke their own conscience, they may invoke the law, they may invoke the precedent, but whatever it may be, but this media will not be totally presented by the minds of the eye and they will take a decision. That's not at all correct. It's not informative. This is about media, role of media. Role of media definitely inform. And I tell you, so much of cognizance also the judiciary takes because of the media report. And there's so much of cognizance in the MC Mehta case, Ganga pollution. So MC Mehta, there was a paper where it was flashed out that there is pollution of Ganga, and the Supreme Court took into cognizance that report and gave a decision. regarding Ganga pollution. So similarly, several decisions are there. So this media report, when it is necessary, it is only accepted by the Supreme Court. Now regarding the foreign, I mean say judicial practices, best practices abroad. It was nicely presented by Isaac Samuel, one of the presenter of the paper, the comparative study. But in the comparative study, it is okay. And in our country also, we have made all laws on everything, but very carefully we apply it. There is a saying, I tell you one thing. There are three categories of persons. One is a doctor. Taking action against a doctor will be a negative portrayal. Similarly, taking against the judge will create a negative portrayal of the judge. It will affect the public. So even though impeachment proceedings have been done, no person has been impeached till now in the history of our nation. Why? Not that we are incapable, but that we want to preserve the sanctity of the judiciary. That is the main point. So these things have to be kept in mind. Everybody knows everything. I also know everything. We are talking also about politics and judges at the pan shop also. So everybody knows everything. But we have to also look at that point of view that how a action will be taken against the judge. See, this is about the, so whatever judges inquiry act, many acts have been made, but there is there. Judges have been punished, but nobody has been impeached. That is the thing. And regarding the reforms, several reforms are already in the pipeline. But the main problem is the money. Money is also the first reform is appointment of that is the first reform. Appointment of the number of courts, the second reform. Appointment, for example, Gram Nyaya. Number of Gram Nyayas are expecting that has not been established. So Gram Nyaya is very, very important because at the grassroots level, Gram Nyaya and from there to district judge. There is no other court in between. So that Gram Nyaya is very important for which information is necessary. The next thing is our human rights code. Protection of human rights code may everything is there. That human rights codes will be there because nowadays whatever you talk of human rights only. And all human rights cases go to the Supreme Court. And Supreme Court judge once said, when there is a case of human right, I keep aside all the cases and look at human right only. Because that is so important nowadays. Therefore, keeping in with that, the protection of human rights law made a provision to establish human rights, but till now no human rights code is established in the nation. So that is a great problem for us. And next to that, administrative court. Administrative court, if administrative court is not established, all cases will be piled up in the court, particularly the service matters, and there will be a headache of the judiciary. So at least one administrative court, only administrative matters. It is done in America, it is done in France. So at least one administrative court. I have been suggesting this from every platform when there is an opportunity for me. But after all, nobody cares about that. Anyway, these are the certain reforms which are necessary. And by the way, because the country is overpopulated, like 147 crores, and this country is a heterogeneous country, means people of different categories in it. So when once law is made, that it will not satisfy everyone is the next impossibility. It is because of the heterogeneity. And therefore, Jeremy Bentham, one of the great philosophers, said, the judge when makes a law, if there is criticism, don't worry. Criticism will be there. Because there must be a particular category who will criticize, because that is not acceptable by that category. So what is the solution? So Jeremy Bentham said, when a law is passed, it must satisfy greatest happiness of the greatest numbers. Whether greatest, many people are accepting this or not, then it is okay. But to counter to it, that human right is now always in class. Because when you are talking of homosexuality, living in relationship, all these things are not accepted by the majority in our country. But that is why it is becoming very difficult for the parliament to make a law. That's the whole problem. Judiciary satisfied, okay, because every person has a right to be fulfilled and the judiciary done it. But to make a task for the nation. So these are the things for which the culture is always a great obstacle. Once Savigny, one of the great philosophers, has said, please remember, custom, culture of a nation, ये होची लोकंकर आत्मा मस्जिद तांगे नहले मंदिर को न जाके जाके सोमवार पूजा न करे सरला पे महालक्ष्मी पूजा न मांस खारो ठीक परिबो से जो कल्चर टा हम पाखे अछि भारत वर्षरे से कल्चर टा ए जो सिविलाइजेशन जो आसी ए सिविलाइजेशन में कल्चर को कॉन्फ्लिक्ट आ आपको ह्यूमन कोड कौन ए कल्चर को देखियो ए सिविलाइजेशन so this is a conflict and I told you once the judge is not trying the case the judge is only trial he is only trial while trying he is on the trial what to do and what not to do so therefore we have to respect our judiciary the highest judiciary and we must be faithful to the judiciary and I told you everyone is a supreme court and the conscience is the great arbitrator so let us be conscientious and save our judiciary by a collective effort with these few words I once again congratulate all of you for your presentation of the papers for your joining this seminar I hope and believe in the future also you will do the same thing thank you now all the best.
Thanks a lot, sir. So, as a matter of fact, he never fails us to give a proof that he is a fantastic orator with his profound knowledge regarding tricks and tricks about the subject. The way he beautifully defined the entire gist of this 2 days, complicated, very lengthy seminar, and out of all the abstracts, judiciary should be respected and people should develop, should inculcate the faith upon it, and for every individual, he or she himself or herself is the highest arbitrator. Thank you so much, sir, for your beautiful words. I now would like to request our Assistant Professor, Ganjam Law College, Shri Loknath Patra, sir, to consolidate Rapporteur's report. Over to you, sir.
Thank you. Respected chief guest of today's valedictory function, Sri Pavitra Mohal Samal sir, Principal Secretary Law Department, our conference chair, Professor Dr. Vinayak Patnaik sir, convener, Sri Manoj Kumar Jena sir, distinguished dignitaries on the dais, learned resource persons, esteemed delegates, faculty members, research scholars, and dear students. It is my privilege to present the consolidated rapporteur's report of the 2-day national seminar on judicial accountability, strengthening public trust in the judicial system. So first thing I would like to say, for the complete 2 days, we have spoken about judicial activism. And in this, the most important thing we all spoke about articles from Constitution. But I'll tell you something which is quite miraculous. What is our Constitution? It is derived from many countries. As we see, we have brought something from US, something from Germany, something from some other. That means our Constitution is the largest and we have adopted the best practices from the best of the countries. But now the question comes, when those 10 countries they made their constitution, what they refer to? Which constitution they refer? You will be surprised. They refer to the Manusmriti of India. Our Indian knowledge, they actually referred and they made their constitutions and we adopted that constitution. So whenever we talk about judicial activism, I think we should go back to our history, our culture, our scriptures, where everything is mentioned. Anyway, let us come back to our seminar. It was a marvelous seminar with more than 220 registrations. When we thought of this seminar, we thought probably we could achieve only 100, but actually the figure is I think more than 240. It is more than 240, but as per the list I have, it is 220. It's really a great thing. And we had from different parts of the country. We had from Mumbai University, Goa University, from Karnataka, from Punjab University, from across the country we had participants, both offline and online. The seminar was conceived with the objective of examining the dynamic relationship between judicial independence and judicial accountability and its direct bearing on public trust in the justice delivery system. As highlighted in the seminar brochure, the deliberations aimed at identifying institutional, procedural, technological, and normative mechanisms to strengthen transparency without compromising judicial autonomy. The seminar was conducted in hybrid mode, enabling both offline and online participation from academicians, practitioners, and research scholars across the country. First of all, I would like to thank Vinod, who is here. He is a student of third year LLB, for whom today the 2 days national seminar could be live on YouTube. So it is a great achievement for this college itself, because entire 2 days we were live. Not only the participants here, people from across the globe, because I had seen there were some from America, some from London, they also watched this. So it's really a great matter that this seminar, even though we called it as a national seminar, but our participants are there from the globe. Yesterday we had the inaugural session. As per the program schedule, the seminar commenced with the ceremonial lighting the lamp, followed by the national song and national anthem. The welcome address was delivered by Professor Dr. Vinayak Patnaik, Director and Principal in charge of this college. The guests of honor, Professor Dr. Banerjee Chakka and Dr. Soumitra Kumar Chatterjee, they delivered upon institutional reforms and the evolving judicial ecosystem. The soft copy of the compendium of abstracts was formally released. The chief guest, Professor Dr. Kamaljeet Singh, emphasized balancing judicial activism with accountability frameworks. And the best thing what he narrated, as I was saying, he narrated Bhagavad Gita, he narrated about Lord Krishna, he narrated about our Indian system. So from there, he wanted to narrate to this judicial activism. The session concluded with vote of thanks by the convener Sri Manoj Kumar Janasaman sir. The inaugural deliberations laid a strong conceptual foundation by foregrounding constitutional morality, transparency, and institutional ethics. And we started with the technical sessions. The first technical session was, the theme was role of technology and judicial accountability. The chairperson was Dr. Nidhi Chauhan, who is the head of the department, BA LLB Honors, Director, Students Welfare, Madhusudan Law University. And the rapporteur of this session was Dr. Trilochan Linka, Assistant Professor of this college. So there were altogether 16 papers presented on that. There were 10 offline papers and 6 online papers, altogether 16. The session basically examined e-courts mission mode project, digitization of records, artificial intelligence in judicial decision making, online dispute resolution mechanisms, transparency through live streaming of court proceedings. Participants critically discussed the ethical implications of algorithmic decision making, data protection concerns, and the need for digital capacity building within the judiciary. Then there was the second technical session with theme Judicial Activism vis-a-vis Judicial Restraint. This session was chaired by Mrs. Hiranmay Misra, Head of the Department, LLM and LLB 3-year, Director CDC, Madhusudan Law University. And the rapporteur for this session was Dr. Manisha Biswal, Assistant Professor of Ganjam Law College. There were altogether 10 papers presented, 6 were on offline and 4 online. The session basically engaged in doctrinal and jurisprudential analysis of separation of powers, expanding scope of PIL, judicial overreach versus constitutional guardianship, standards for judicial self-restraint. Scholars debated the thin line between the transformative constitutionalism and institutional enforcement. Then, after the lunch break, we had technical session 3, and the theme was role of media in promoting judicial accountability. The chairperson, the session chair for this session was Professor Dr. N.C. Patnaik, Principal Lingaraj Law College, and the rapporteur, Mrs. Sudatta Rath, Assistant Professor of Ganjam Law College, Barampur. And the theme was role of media in promoting judicial accountability. The key discussions that revolved around media trials and presumption of innocence, responsible reporting, contempt jurisdiction, social media, and judicial image. There were altogether 10 papers, 5 in offline and 5 online. The deliberations stressed the need for ethical journalism while recognizing media as a transparency instrument. Today, on the second day, the technical session started with technical session 4, and the theme was best practices from different countries. This was chaired by Dr. Chittaranjan Gogoi sir, the coordinator, PG Department of Law, Barampur University, and the rapporteur for this session was Dr. Jyotirmay Barua, Assistant Professor, Ganjam Law College. And this session had seen 10 papers, 5 in offline and 5 online. The comparative perspectives were presented regarding judicial appointment mechanisms, performance evaluation models, code of conduct frameworks, judicial councils and disciplinary systems. Countries such as UK, USA, Canada and certain European jurisdictions were analyzed for adaptable accountability mechanisms. Then the next technical session with session 5, the theme was reducing pendency of backlog cases. This was also carried on by Dr. Chittaranjan Gogoi sir and Dr. Jyotirmay Barua madam. And there we had altogether 7 presentations, 3 in offline and 4 online. The case management techniques, alternative dispute resolution, judge population ratio. And the final technical session 6, was chaired and rapported by me, Loknath Badra. And the theme was future reforms for strengthening judicial accountability in India. There were altogether 13 papers in this, 5 in offline and 8 online. And there were very good reform-oriented proposals here. So, number 1, transparent collegium proceedings. Second, national judicial oversight mechanisms. 3, strengthening judicial ethics code. 4, institutional performance audits. And 5th suggestion was capacity building and training reforms. Participants advocated and calibrated reform model that preserves independence while ensuring answerability. Key thematic findings in this 2-day seminar were, across all 6 technical sessions, the broad conclusions that emerged are, number 1, judicial accountability is contemporary, not antagonistic to judicial independence. Number 2, technology is a transformative but ethically sensitive accountability tool. Number 3, comparative models offer guidance but require contextual adaptation. 4, backlog reduction is central to restoring public trust. 5th, transparency in appointments and disciplinary mechanisms enhances institutional legitimacy. And number 6, media must function as a responsible democratic watchdog. So, as we have seen, the seminar was participated by faculty members, research scholars, practitioners and students. Almost 89 abstracts had come and which were put in the compendium of abstracts, which is a soft copy and that is available in the group. Everyone can access it. In conclusion, this seminar has meaningfully contributed to the academic and policy discourse on judicial reforms. The deliberations underscore that strengthening public trust is not merely a procedural exercise but a constitutional imperative. Judicial accountability must evolve as transparent, ethical, technology-enabled, institutionally structured, constitutionally grounded. On behalf of all the rapporteurs of individual technical sessions, I extend sincere gratitude to the organizing committee, the distinguished speakers, and all the participants for their scholarly engagement and cooperation. With this, I respectfully submit the consolidated rapporteur's report. Thank you.
Sir, and we thank you. We thank you as organizational secretary. This program and standing over here, sitting inside this hall and enjoying this 2 days national seminar, I don't think would have been possible for any one of us across this globe, as he emphasized, across this globe, without his efforts and to add on to this, without any of our faculty members' efforts. And remember, faculty members never fail to memorize us, to revise us what we have studied yesterday. And thank you, sir, for such huge, short, crisp, and thorough revision. Thanks a lot, sir. Sure, sir. What, sir? Okay, so 2026 Rapporteur General designation goes to Shri Loknath Patra, sir. Thanks to conference chair. So yeah, now the time has arrived for which we are looking forward. Humility is the key to success. Humility and the subduedness is the key value of a person to excel anywhere and to stand tall with the utmost grace and confidence to achieve any height. And therefore, he is already here. So with due respect and honor, I would hand over the podium to you, sir. All yours. Yes, sir.
Of course.
A very good afternoon to all of you. I feel deeply privileged for having this opportunity amidst in presence of the distinguished guest. My profound respect to, please carefully listen. Don't murmur, please. It will take hardly half an hour, not more than that. I will take your time only half an hour. My profound respect to the dignitaries on the and off the dais. Today I feel truly a homecoming. I am not here as a chief guest or a guest, whatever you call and honor me, but I am a humble member of Ganjam Law College. Humble member of Ganjam Law College family. So it would be wrong to say as a chief guest. A member of the family can never be a guest at all. My humble tribute to the departed soul, late Madhusudan Dev, the director of this institution, when I was here a teacher. Nalini Jana Samant, late Nalini Jana Samant, the architect of this premier institution. Bhaskar Sabat, a prominent lawyer, and the Soros, was too younger to all of us, left us. And I pray, Lord Jagannath, for their peace, eternal peace, they rest soul in peace. I would be remiss if I will not mention the name of my revered guru and mentor, Professor N.S. Jagannath Rao. Though he is absent today, his simplicity, his technique of teaching, it is unparalleled, unrivaled, and he is the first delete in Odisha in law. I pray God for his safe health and healthy life. I also extend my sincere thanks to Professor Vinayak sir, to whom I saw from my student career and choosing me as a befitting person to this occasion. My heartfelt gratitude to you, sir. So before delving into the topic, as the rapporteur and Sir also highlighted, the gist, the home takeaway, whatever you may say. First of all, we must understand the meaning of the accountability. What is accountability? The simplest sense or simplest meaning of the accountability is answerability, responsibility, or in a more simpler way, you can say, to hold on your action. That is what is accountability. Therefore, what Sir has said, in our constitutional democracy, the cornerstone, that is the judicial review, is the cornerstone of the accountability. Therefore, here I will share one quote that is the Saint Vivekananda said, Dharyam Sarvatra Sadhanam. Courage is the virtue. Without courage, nothing happens. When I said so, I must demonstrate. Please remember 12th May 1975. 12th May 1975, when the Honorable Judge Jagmohan Lal Sinha delivered a judgment declaring the election of the then Prime Minister Indira Nehru Gandhi by setting aside, and I quote, the word of the judgment that the entire electoral process was marred by malpractice. That was the judgment quoted by the Honorable Judge. Marred by malpractice. Jabardast. Declared her election void. Then immediately, the prominent liar Palkiwala, Nani Palkiwala, preferred an appeal against that order, that judgment. Before a Honorable Supreme Court judge, by that time the summer vacation was there. The single judge, there is no need to describe his lordship's candidate. Krishna here, Justice Krishna here. That was before the Honorable Judge, Justice Krishna here, where that the court has been pleased to give a stay, but subject to certain conditions. What are the conditions? Please listen, brothers. What are the conditions? He will remain as Prime Minister, enter the parliament, having no power to cast vote. Having no power to casting of a vote. Getting some kind of information. Palki Bala wrote a letter to Indira Nehru Gandhi. That is the case of Raj Narayanan versus Indira Nehru Gandhi. Getting some sense, getting some informations. Palki Bala wrote a letter, Madam, this is not the time to clamp emergency. In spite of that, Indira Gandhi clamped, Indira Nehru Gandhi clamped emergency. Then he left the file that I will not argue a case. That is the courage. You see the courage of the advocate, you see the courage of the judge. That is what I am supposed to justify the accountability. Courage of judge declaring the election of the then Prime Minister as a null and void. Then Indira Gandhi barred. By that time, number of leaders were kept behind the bar. You can also read the IDM Jabalpur case. That is a celebrated case. You can read and you can understand what that has happened by that time. Number of prominent members were kept inside the jail. Coming to a village magistrate. It is a very interesting story. Please listen, because tomorrow you judges of the country, judges of the state, or prominent lawyer of the state, please keep remember in mind. One of the village magistrate, if you will read the history, if you are not in even a moment to sit idle for a 15 minutes or half an hour, what we can expect? Please, because it is a profession, my dear students. Once you indulge into this profession, the only option is you have to read. There is no other option. When I had to take one class in Jaipur Law College, when I was the judge family court at Jaipur, I had the occasion to visit the Jaipur Law College. Then the film RRR was released. When I asked all the students, have you seen that cinema RRR? All the students raised their hands. Yes, sir. Yes, sir. Then I asked, what is that RRR? Everybody remained silent. Everybody remained silent. Then you might have seen that cinema. Can any one of can say that what is that RRR? No. That is what happening to all of us. So that is, unless you read, unless you know the meaning, unless we are observing the superficially, then rise, roar and revolt. Then I converted it triple R into triple R in our profession. What are these? Reading and reading. 3 R. No option. Reading and reading. Cinema is meant for entertainment. 3. We are here to only, we must carry with you only 3 R. So this one village magistrate, please, his name was Ramasastri Prabhuni. His name was Ramasastri Prabhuni. It is the Maratha story, Maratha history. Viswarabaji 2. That is the Maratha. You can also search in your mobile. Rama Sastri Provene was a third class magistrate. Before 1973 CRBC, now we have a new BLSS. At that time, the third class magistrates were there. Now we are having the second class magistrate, first class magistrate. Judicial magistrate, first class, judicial magistrate, second class. By that time, third class magistrates were there. What he did, that is what I am going to share with you. A small village judge or municipal or magistrate, where the case may be, one day when he came outside the court, after court hour, he saw outside the court a lean woman with a lean child. One lean woman with a lean child. Then he asked, what happened to you? That woman said, I have not got any maintenance from my husband. You see what the judges are doing? Even after the court hours, you see the person and you see the compassion. Asked, then he said, my husband is not sending me the maintenance. Immediately he issued someone to him. He was serving in the soldiers, as a soldier. He appeared, said, sir, I have not received the salary. Because my commander, my authority has not given the salary. Then again he issued another summon. It is there in the history. You can read subsequently, not right now. Please listen. Don't write anything. Then the commander appeared. Commander said, yes, Raja is not releasing the fund. How can I give the salary to him? If the Raja is not giving, then the village magistrate issued a summon to the Raja. Viswa. You see the courage. Viswa. Then the Viswa, when he issued summon and for appearance, Raja, here's the Raja. The eternal manifestation. Who is this person? Issued a notice to a Raja. Raja Sarvatra Pujyate Durakumanvi. King can do more. Who is this fellow? That was the courage of the judicial small and little magistrate. Even coming to my experience as a judge family court in Jaipur, very interesting story. Because the judge family court means only the family disputes cases will be referred to my court. All family dispute refers. In one case, that is the heart touching, and wherever I go, I say that story to all of you. Wherever I got the opportunity. The couples were from Pune, and one was posted at Mumbai. Both. They are the software engineers. Both the software engineers. After 6 months of their marriage, they lived separately from each other. Some kind of a dispute. They filed a mutual divorce before me. Mutual divorce filed of country. That case was after 6 months, that is the cooling period. After 6 months, I posted the case for hearing. And the advocate came and approached me, requested me, sir, let the case matter be taken second hour. Our first session 10:30, 11 to 1:30, 2 to 4 p.m. 2 to 4. We used to sit in our tiles. They arrived in my court around 2:45 p.m. Please, 2:45 p.m. Both of the wife and husband approached. I went to my court tiles, put all my dresses. The moment that lady came to my witness box, court witness box, there was a profuse tear came out from her eyes. She couldn't tell even her name. I sat for a few minutes and observed. I could see her feelings through her tears. Then I stopped writing the deposition. and called both the wife and husband to my chamber. Then I asked, what is the problem? Why you are crying? You have to find the mutual divorce. After a cooling period, I have called you to record your deposition to severe your status as wife and husband. Another wife and husband, simply an order to be passed. Then she said, it will be very heartening. Sir, we have no problem with each other. The only problem is my
In-laws.
my mother-in-law. That mother-in-law was a widowed lady. They are Bengalis. They were Bengalis. And as that date was fixed for order of mutual consent divorce, some of he had family members, some of the groom's family members were also present. The husband said, if my father-in-law, means the father of his wife, if apologizes my mother, I will take my wife to, and we will stay together. By that time, you see, their marriage was happened in 16, lived only for 6 months, and they're living separately for 4 to 5 years. You see. Then what happened? I called, left both the wife and husband, I called the father of the wife. Sir, tike क्षमा मागी दियंतु, so that आपनकर झियर गोटे husband ta मिसिकरी रहिबे. How tike मागी दियंतु. That was his male. जेहेतु से male, how he can ask apologize to the mother of the Samundri. It's quite embarrassing. You see, it's quite embarrassing. Still I convinced him. Still I convinced him, and he convinced. But when I again called, father went away, father left my chamber, again I called the wife and husband. Husband, what he said, it will again a story. What the husband said, no, orally call the husband. See our patience, the judge's patience. We must not lose our patience. That is our hallmark. I didn't lose my patience. Still again I called the father of the wife, and I handed over. And in the meantime, the husband and distributed all the courts, all the car stops and